It's may please your lordship.
So in
No. This is a matter where Gopal Subramaniam, my friend, was appearing on the other side. That 1400 crore matter. Your lordship directed to be listed on the 7th, and it was
what's the matter?
the 1400 crores, where the award, 1400 crore, the 36% interest, your lordships. Now your lordships had directed to be listed on the week commencing 7th. It was shown for the 8th, but suddenly it disappeared overnight, Would my lords be then fix it?
Lordship may have it after 2 weeks.
Why 2 weeks? Why 2 weeks?
Lordship, next week, Mr. Subramaniam is in some difficulty.
But this is not.
You just move a slip. I'll just ask them to fix the date.
Yeah.
Why was it removed?
It's just shocking, It is, but it is,
It does. Unless it will be listed accordingly.
Deeply obliged, Let it come up any time.
With your lordship's most gracious permission, my lord.
Yes,
your lordship would ask why you are mentioning. Because, my lord, we are mentioning because otherwise the registrar will lodge it.
No.
My lord, now, my lord, 5 times the former Chief Justice said, we'll constitute a bench, but it was never listed. The registrar.
What direction are you going? Please tell us.
No, my lord, NJAC matter, my lord, it has to be revisited.
We'll take it up.
No, my lord.
I have sent an email, my lords.
It will be all taken up. It will be all taken up.
Just flagging it. This is the West Bengal teachers matter, my lords. Your lordships had terminated all of them.
Please.
We have administrative difficulties which we had said. The board.
Pardon me, please. We have said so many times, and I'm repeating it infinitum now.
Please, my lords.
Repeatedly every day. Any mentioning, just move a slip. It is taken up the same very day. If it is done afternoon, it is taken up the next day.
Please, my lords. We sent
if you do it by 10 o'clock in the morning, it comes before me at 1 or at 2
We
o'clock.
sent it last night also.
Same day. If you've done it last night, it will come up before me at the after lunch.
No, we agree that, my lord.
No.
Your lordship has done
the
that.
request is for tomorrow.
But only difficulty is.
Whatever is possible.
Please, my lord.
That don't insist. We have to.
No, I know.
My lord, your lordship has done it, my lord. We are very obliged. Only thing is, my lord, we need a specific date. We need a specific date.
I am the petitioner in person in this NJAC case, my lord.
In?
My lord, this has been dismissed by the registrar. It has been lodged. We had filed.
What is NJAC case? What is NJAC?
No, my lord, we are seeking a revisiting of the NJAC case. And my lord,
let's move a mentioning slip.
And give us a date, my lord.
No, please, sorry, nothing like that. I've told you, please move a mentioning slip.
We are done, already done.
That's
And the public persons are waiting outside.
Please, do not do this. We have ensured that no mentioning is done. Otherwise, at least 15-20 minutes in the morning are taken up at this. Stop it.
Yes, my lord. Yes.
My lord, this is the case about the non-arbitrability of mortgage. My lord, since we had been protected since 2013, my lords had deemed it fit to continue the protection for 6 months.
No, sorry.
My lords,
Sorry.
Is online in this matter, so I believe what was said was 6 months.
My lords, in the while the my lords, I'll give a context.
My
lords, with the utmost. Sorry,
even if it was stated 6 months, what I meant was 6 weeks.
My lords, and can I request one thing? My lords, could it be 7 weeks in that case because a week has passed? My lords, the summer vacations are also coming.
No, doesn't it? Summer vacations are still far off.
My lords, the only difficulty is to hear the matter.
Sorry.
Get a stay. My lords have been protected since 2013, my lords, when the arbitral award was passed.
If you are agreeing it's 6 months, then you.
is online.
My lords,
I was very clear. I was giving 6 weeks, which is more than sufficient.
But my lords, I may be at Mr. Puvaia's mercy right now, but we heard.
Did I communicate 6 months or 6 weeks?
My lords, let me clarify that, my lords. I had said 6 months. Your lordships had said 6 weeks. So it is correct that I had said 6 months. That much I must be clear, my lords.
My lords, in that case, could it be extended by 1 week?
Sorry.
Humble request, my
lords. Nothing.
My lords, there would be certain vacations ensuing within a few weeks, my lords.
How much time does it take you to draft a?
My lords, I understand.
Please,
Just for the stay, my lords, because
that is
obliged, my lords.
My lords, may I mention, I listed today, I had mentioned yesterday as well, my lords, the learned counsel is not available.
Which matter?
Item 45, your lordship.
When it's come up,
we have complied with your lordship's order, my lords. We can file an FIR, filing an FIR. We have complied with it. My lords, we are given directions. Minimum, my lords.
There was no problem?
No problem.
The hospital supplies, etc.
Yes, yes, maintained. And we'll file the affidavit, because we have an affidavit on record.
Right up.
Yeah.
In view of the order passed, it is stated that the order passed by us on. Copy of the order is not there. When we passed the order,
Mullad's your-
4th April
Yes,
2025.
No, order dated 3rd April.
3rd April. No, our order.
4th April. 4th April. Yes.
Order date passed by 4th April 2025 has been complied.
We can place an affidavit on record in compliance with it so that it's on record.
Hence, the present specially petition is rendered in bunches and is disposed of.
Deeply obliged.
Yes, please.
Lordship, in item 42, I appear for Roche. I'm requesting for a passover. Lordship had on the last occasion issued notice.
Call the council.
I will.
2 o'clock.
2
Because
o'clock.
all matters pass-through matters are taken up at 2 o'clock.
I'll call. Much obliged.
Whereas in this matter, Mullad's, what had happened was your lordship aggregated, Mullad's, the supernumerary matter from the others.
Correct. So,
Mullad's, we moved an application, Mullad's, we had moved an application to bring additional grounds on record.
1 minute, please. Argue on that part. Let's see what you have to say. Because we had virtually disposed of the entire matter.
Yes.
Who's appearing for the other side?
We are for the red petitioners then.
Look, in this case, it's a cabinet decision which is taken on record. And that was taken in 2022.
That's right.
I went through the cabinet notes.
Mulad,
We really can't go into all that.
required to be seen, Mulad. That cabinet decision, Mulad, I'd like to read also, Mulad.
Yes, let's see.
With the 19th.
Just 1 minute, please. If you require help and assistance, we'll take. Just give me that.
They wanted to, Milord.
1 minute, please. Just turn to that.
Can see.
Just 1 minute.
Yes.
Let me take out the file. Giving the consent.
Does not have the.
That cabinet decision.
Scan through this file. You have this file, this one.
Can 6 Milord possibly would be one of the applications, Milord?
Just give him the copy. Just take out this file.
Milord, it is an IA 87607, which was filed, Milord, day before yesterday, possibly.
No application can be filed at this stage after the matter has been disposed of.
87607.
Please study for the, look, we have the copy of the minutes.
Yeah.
Dated 5th of May 2022.
Yes, that's the
Correct? That's a cabinet memorandum.
right. On that basis, Milord, an application is made, Milord.
But I'm not concerned. I'm just going to the cabinet memorandum. If you have that, please take us.
Yes.
And how do we get into all this? Keeping in mind the constitutional provisions that aid and advice given by the Council of Ministers cannot be inquired into and gone into by the court.
My lord, can we take up the cabinet discussion? That is very important. 5th of May 2022.
Whatever it is, please, yes.
Yes. Now that
Can we go into examine that?
If there is an illegality, my lord, your order.
No, please. That is not an illegality. There is a note prepared. It's the decision taken by the cabinet. And normally we do not go into that. there are restrictions starting from the earlier, there are number of judgments dealing with it. Even Ketananda Bharti deals with it to that extent. We need not go into all that. Their facts are stated at that time in 2022. There were two views being floated around. There were certain irregularities noted. They then cabinet decided that let's take supernumerary posts.
Whether Milord cabinet could decide, Milord,
We will not be able to. We will not step into that question.
no, but I am not on the wisdom. I am on the question of constitutionality.
No, even on constitutionality.
If the
1 minute, please. Constitutionality aspect we have already decided and struck down that.
yes,
Now the question is whether the cabinet decision in this case should be referred to or made subject matter of CBI investigation. It's a decision taken by the cabinet as a whole.
yes.
On the aid and advice they have given, then the matter went to the governor. The governor has issued the order.
Right.
And succeed.
My lord is probably
Sorry, we're not.
asking the question about the CBI investigation.
That's all. That's
That-
the only limited asset.
It's
And
not
what is the reasoning given by the High Court is also
That's very
not really, not,
Para 257.
I've gone through that. It doesn't really, just,
the CBI investigation is called
I've
for.
seen that it doesn't go into all those aspects.
Para 257 on In fact, they were all illegal appointments, my lord. And that
1 minute, please. That's not the issue before the cabinet.
No, that is firstly.
No, Mr. Baninder Singh, that's not the issue.
Just give me 2 minutes, my lord, in my turn, whenever your lordship want to hear.
My lord.
I'll show from the cabinet,
Okay.
it is founded on, kindly come to the cabinet note.
Cabinet,
1 minute, one person at a time after he is over.
Yes, after letting me over, I only need to.
cabinet decision Milord is initiated by the school service committee, holding that the post be filled up for the waiting list candidate when admittedly the list was exhausted. As per the rules, there is no existence of waiting
They
list.
had the power to relax the rules and therefore
They-
terms of that they exercise.
Milord, they don't have the power, Milord, to create posts like
Okay.
that. Kindly comes to statutory rules once. Excuse me. I know, Milord, the limitation of the constitutional court not so far the directing investigation is concerned. But if the court's conscience is satisfied, which is satisfied in Arbitration Matter, this is absolutely per se illegal, unconstitutional. Here also, the cabinet memo was prepared only to ensure that the illegal appointees are protected. Whereas the rules permit the state to create supernumerary posts.
for illegal appointments.
Now, the concept of supernumerary means, Lord is well aware, in a cadre service where the number is fixed, if someone else by chance is there, but he is beyond the strength of the cadre, then by a supernumerary post, that job person to the person is not secure. But here the supernumerary post to create a vacant post for the purpose of fresh recruitment. Whether that is as per the rules or whether constitutional
Do
permission.
you realize the consequences of your argument?
Hopefully so.
Sorry.
Lordship, only
1 minute, please let him be over.
If
We'll hear you, Mr. Baninder Singh.
I will wait.
the vacancies are to be created but should be kept
Okay,
open
we have
for all. That
understood. We have
article.
understood. We have understood. Yes,
Your lordship may kindly see, my lord, para 257 of the impugned judgment.
yes, please.
Because this my lord, supernumerary post, my lord, should be read in inverted commas. I'll make good the argument, my lord. The lordship may see, my lord, how the learned division bench, my lord, they read about the role of the state government. Para 257. The role of the state government in the writ petitions and the appeals that have been heard by us has to be taken into consideration. As has been noted before, SSC filed CAN 6, and I will read this CAN for your lordship's kind consideration, in writ petition number so and so, my lord. SSC, that is the commission, had prayed for creation of supernumerary posts, very good till this extent, in respect of appointments given illegally. And this is the part of CAN 6. And I will read the paragraph of an affidavit sworn by the Assistant Secretary of the Commission, which says that the supernumerary posts are for illegal appointments. I'll read that paragraph, CAN 6. State government has not opposed such a prayer. In fact, documents placed on record suggest that the state government at the level of the cabinet had approved creation of the supernumerary post to accommodate the persons who had received employment illegally, and that is the word used in the application. In the said selection process, the principal secretary had appeared before the learned single judge and produced a cabinet note. Now, your lordship may kindly see page 265, para 265.
Yes.
May I read the paragraph?
Yes.
The state government therefore has accepted that there were widespread illegalities in the selection process and that the number of persons who had received appointments illegally could not be determined with exactitude. They had resolved to create supernumerary posts to accommodate the illegal appointees.
Look, this discloses the reason. What happened was, there were certain candidates who were found to be tainted. On that, there was no difficulty. They themselves had removed them or even shunted them out without following the inquiry procedure. One. Number two, they were with the, at that time in 2022, they were of the view that we cannot now segregate who are the other tainted candidates. So in order to benefit the people who are on the waiting list, they said, let's create the please do not interrupt like this. They created the supernumerary, they decided to create a supernumerary post, and the cabinet decision also says in the end, this is subject to the writ petitions already pending in the court.
Correct.
If that is so, how can you say that?
The reason, I'll read it.
How is criminal investigation, that too by of a state government cabinet decision be taken by a central agency? Will it not defeat the entire purpose behind federalism?
Today, Milord,
Until unless there's something much more, that too we'll have to examine in terms of articles of 74.1 and 74.2 and 163.3. We'll have to examine all that.
Today, Milord, with great respect, Milord, let us.
So, and this reasoning of the High Court dealing with the CBI inquiry with regard to that is, are they dealing with any legal issues? It doesn't even
So,
examine.
two submissions on that, Milord. Your Lordship may kindly see, Milord.
Anyway, we don't have to.
Only one submission then. Only one.
Please answer this if you have.
Yes, I would, Milord. I just read, Milord, para 6 of Can 6, which is filed, Milord.
Yes, please. Which page?
Milord, it is in Can 6, Milord. It would be paragraph 5, Milord, because your Lordship.
Can 6 is what?
Can 6, Milord, is an application on the basis of the cabinet decision.
That's a case for cabinet decision?
Correct.
Dated 5th of May 2022?
Then they swore an affidavit to this extent on 27th of September 2020.
Which portion of that?
Yes, Milord. Now, your Lordship may kindly see, Milord, if they want to come clean, then para 6 should not have been incorporated in this.
Yes.
In such circumstances, may I read para 6?
Yes.
In such circumstances.
Para 6 where?
Para 6, Milord, of the application.
No, don't read your application. Read the cabinet notice.
No, I would, Milord, but on the basis of this.
Okay, fine.
Yeah, the application is preferred before the Honorable Court, Milord. So the application is filed on 27th of September and para 6 is relevant.
Paragraph 6. Yes.
Milord.
Yes.
Not para 6, Milord.
The applicant states?
In such circumstances, Milord.
No.
It is, Milord, IA number 87607. It's the thing volume.
We've got 87607.
Yes.
Paragraph 6 begins.
Para 6
Your applicant
page 13,
states
Milord.
that such discrepancies and illegalities.
Page 13, Milord.
Yes.
Milord, may I read, Milord?
Yes.
In such circumstances, it is humbly proposed, your Lordship have it, Milord, that apart from giving recommendation and appointment to genuine candidates as observed by this Honorable Court in other similar matters, supernumerary posts to be also created to accommodate those,
This is
if
wrong.
any, whose
This is
appointment.
wrong. This is absolutely wrong. This is not what the cabinet decision.
Milord, this is what
No, this is not what the cabinet.
Milord,
That's
who swears the affidavit? Milord,
Just come to the cabinet decision.
I got, Milord.
Come to the note. What's the cabinet note?
Page 15, Milord, it is sworn
Just
by the
1 minute,
Assistant
please.
Secretary
I-
of the Commission.
I have said this is wrong. If this was a purpose, it is wrong. Just come to the page number 4 of the cabinet decision. Cabinet note.
Yes.
That was triggered by SSC.
Please, you have argued. Do not interrupt now.
When I am not interrupting, I shall argue again.
So
So,
you will
Milord,
intervene at your time, not at somebody else's time.
Milord, today, Milord, your Lordship.
That the
say, Milord,
state government may be permitted to issue, just come to page number 4, paragraph number 3B.
the state government. May I read, Milord? The state government may be permitted to issue necessary direction to the Commission by invoking Section 19 of the Act, and to the West Bengal Board of Secondary Education in the interest of education in terms of Rule 3.2 of the Education Appointment so-and-so Rules 2018 for absorption of such waitlisted candidates in the proposed supernumerary post to be created with the approval of the Cabinet. However, the same shall be subject to outcome of pending litigations before the Honorable Court.
Correct. So that was the object, and that's the reason why they have done it. And if you turn to the cabinet decision also, which is then communicated.
With great respect, because there is no application filed that waitlisted candidates will
Sorry, please.
be accommodated.
Sorry. Yes, Mr. Lord.
Today only one submission.
That's all, please.
Only
That's
half
no,
a
please.
minute.
That's over.
Today your lordship.
So please, you have argued. Yes, Mr. Maninder Singh.
My lord, first submission. My lord, even the parliament, my lord, the legislative power or by power by the cabinet, my lord, on any issue, my lord, is founded on illegality noted in the note itself. Then that is a colorable exercise of power. That is complete absence of any bona fide, and the immunity and protection to the cabinet decision making, my lord, will not come into play. Kindly come to that cabinet note, the second para of para 2.
Yes.
If, my lord, if
Mr. Maninder Singh, you are appearing for whom?
my lord, for the writ petitioner, respond number 1, my lord.
Did you make that prayer in the writ petition? Did you make that prayer in the writ
This
petition?
has come during the proceeding.
No, please. Did you make that prayer in the writ petition? You should have amended the writ petition.
My lord, kindly see, my lord.
Mr. Maninder Singh, answer the question. Did you make that prayer in the writ petition? Yes or no?
At that time, it was not even.
Okay, fine. That we take it that the reason you're not answering it either way is you did not make.
Yes, my lord, it was. Now, may I just show that paragraph, my lord, to your lordship?
Okay, fine. Now the second argument. Can such a prayer or issue be?
That's what I'm answering, my lord. If, not just for 1 minute, my lord, your lordships have read the note, your lordships are asking me to read the note, only one paragraph.
Yes.
It is not, my lord, with utmost respect, not simple, my lord. There is a distinction, there is a bifurcation of a bona fide decision making and a decision making which is colorable. Now, my lord, the note itself is founded on the basis that there are appointments which are not in any list. Kindly have a look at para 2.
They are not defending those appointments.
Not on appointment, my lord. If it says, if commissioner says, these appointments are required to be cancelled, they are out of no list. Kindly permit me to read 4 lines. The chairman, West Bengal Central, my lord, I am para 2, subclause 1.
Yes,
subclause 1, my lord, and kindly come to subclause that unnumbered para. Can I read it? The chairman, West Bengal Central Service Commission, further later dated placed a report to the state government stating that there are 751 who are not in any list, either in panel or in wait list. The West Bengal Board of Secondary Education has also confirmed the fact of such appointment of non-teaching staff beyond the list as reported by the commission. The chairman of the commission further stated, for teaching posts of so-and-so who do not feature in any list, either in panel or in wait list, should be cancelled by the commission. Now, my lord, this is not one of the views. This is a factual position of illegality.
They are recommending cancellation.
No, my lord, kindly this.
What else do you require, Mr. Maninder Singh?
My lord, my lord, please, my lord, visualize the situation that blatant illegality is noticed.
They are not condoning that.
No, my lord.
They are not asking you to condone that. They're not asking that it should be overlooked. All that they are saying is, now that the panel list is over, everything is over, we cannot now carry out further investigation. So let's accommodate the people on the waiting list so that they can be also given.
My lordship, 1 second, my lord.
That was the object.
1 second. If, my lord,
how can you attach criminality to it? I don't know.
1 second, your lordship would permit me, my lord.
Is it so simple? Cabinet decision being.
My lord, if a cabinet decision note is.
You have argued that, Mr.
No, I'm only
saying factually this is not flowing from that.
No, this is that there is a report, there is a letter. There is a report that this illegal admission must be cancelled. Lord, on this, the CAN 6 is filed. Lord, with utmost respect, if supposing the illegality is at the bottom of any decision making, admittedly, there is no dispute on this, that these appointments are illegally made from no list.
Okay. That, Mr. Do you have to want to add anything, Mr.
Appointments have been made. Because I don't know what my understanding is.
Only one thing.
Only one submission.
With my lord's permission.
I have filed an IA In connection, not only one this part.
The matter is over.
The timely pardon, kindly pardon. We are not covered by the recruitment process. We are not teachers who were appointed.
You are nobody, then please your listeners blind.
Work education, physical education, teachers not covered by this.
Okay, fine. Mr. Civil, you want to add anything to what?
No appointments have been made under this cabinet court because of those
Right
in the wait list.
My Lord will just listen now. Let us take one. Pursuant to our decision.
And under 163, your lordship is aware.
In terms of our decision, from judgment, in terms of our judgment dated 3rd April 2025, white paragraph 52, which white paragraph 52 has held from observe that the issue with regard to direction of investigation by the Central Bureau of Investigation is a decision to create supernumerary posts will be dealt with separately. We have heard learned counsel for the parties. To stop. Next slide. In particular, our attention is drawn to paragraphs 257 and 265 of the impugned judgment. Full stop. Next page. We have considered the amendments made, the observations made in the said paragraph. Full stop. On a pointed question, it is accepted that the writ petition, in the writ petition, no specific prayer.
Hello, now you can see me.
The cabinet decision. Was the cabinet decision dated?
Yes, you can.
19/5/2022. Consequent to cabinet decision, consequent to which order dated 19/5/2022 was issued by the government of West Bengal after approval by the governor was specifically challenged. Full stop. Neither was any prayer made that this order should be made subject matter of any investigation by the police or the Central Bureau of Investigation. Full stop. Next page. A perusal of the note dated, next page, 5th May 2022, which makes out the case for cabinet decision, would records that the power under section 19 of the West Bengal School Service Commission Act 1997 is being issued, maybe issued in respect of wait-listed candidates, but the same shall be subject to the outcome of the pending litigation given before the High Court of Calcutta. Stop. The cabinet note, the case for cabinet and the cabinet decision was taken at the time which is accepted when there was there were pending litigations in the High Court, and the possibility of finding out by thorough examination the list of tainted candidates was not possible. Full stop. It is pertinent to note that the case for Cabinet Note, decision dated 5th May 2022, specifically mentions the view expressed by the Central School Service Commission that they were wrongly appointed candidates by way of rank jumping, etc. Nothing was hidden. Full stop. Next paragraph. Having regard to the aforesaid facts, having regard to the aforesaid discussion, we are of the view that the High Court was not justified in referring the issue of creation of supernumerary posts pursuant to the cabinet decision to investigation by the Central Bureau of Investigation. Just record one more thing. It may be relevant here to reproduce, to take note of clause 2 to Article 74 and clause 3 to Article 163, which specifically states that the question whether any, and if so what, advice was tendered by the Council of Ministers with the Prime Minister as his aide, to aid and advice of the President. Advice was rendered by the ministers to the governor, shall not be inquired into in any court. The aforesaid direction is therefore set aside and quashed.
Only with respect to the investigation.
Pardon?
The Malad is only part of investigation.
Pardon?
Quashing the part of direction.
No, that's fine. That's fine.
Nothing, but so for the pending matters are
no, we are not touching.
Yes.
We clarify that the directions, that our observations and directions given in this order are limited to the extent of the direction for investigation into creation of supernumerary posts and do not in any way impinge or reflect upon the investigation and the charge sheets filed by the Central Bureau of Investigation in other cases.
And also the
other aspects.
And the pending repetition also.
Pardon?
And also
obviously the repetition stands
Well,
for
why is my
record. Otherwise it will be confused.
That's so there is no confusion.
Very well.
okay. Deeply obliged, miss. Deeply obliged.
Gone, gone and forgotten now. Great case.
Only to, I see, my lord, but only two couple of things. The aspersion which is being put on the petitioner, my lord, in the impugned order, the entire.
I don't know whether correct or not.
No.
Judges of that court know what you went.
That's why I can show it from the writ petition. Whatever he had alleged were based on the RTI responses which he had received, number one. Number
After
two.
11 years.
No, not exactly. No, that 2011 is the FIR itself. Just wanted to show.
It's
2006.
Are you a political person?
Yes. And it's been disclosed in the writ petition. I did not.
Okay, then the query answer is also.
But only one observation. There is an FIR which is going.
We are not.
Pending. It will not come.
Saying anything more. We are not inclined to interfere with the impugned judgment and especially petitions dismissed. Next case.
But that impugned is in the nature of an intent.
So, you've been punished?
Blood or Lordship only dispose of this petition with direction. Both the petitions are pending.
Which petitions? Against your inquiry result?
Against my dismissal and presently government.
The present specially petition is rendered infructuous, as it is pointed out that the disciplinary procedure have culminated into an order of dismissal, which is under challenge before the High Court.
That is pending.
In view of the aforesaid factual position, the present specially petition is dismissed as infructuous. We clarify that the impugned judgment and the order passed dismissing the specially petition as infructuous will not have any bearing on will not have any bearing or effect on the writ petitions pending challenging the order of dismissal.
All the questions may be open to me.
All questions are left open.
Great. To be declared before the High Court.
All pleas and contentions will be examined by the High Court.
Okay.
Great.
Lord, the High Court. Lord, the High Court has decided this petition beyond the relief.
What happened to your second appeal?
That second appeal is pending. In fact, it has been clubbed with the suit. There is also a suit filed by us, Lord, because for the construction.
Order is correct. How can you build on a water body?
May I tell you, Lordship, we are not made parties. The relief sought is decide our representation. The High Court says no, as if on the assumption that we have actually covered the pot.
You have?
No.
What else?
No. Kindly see. There are orders in our favor. Lord, they suppressed the.
What is the position now? Is the civil suit pending?
That civil suit, my lord, is for
Lord,
compensation. Is praying for release of compensation for part of the land acquired belonging to the temple, my lords. That has nothing to do with second appeal. That has been dismissed.
The second appeal has been stopped with that.
SANJIV is wait for your turn. Let the make a statement.
Yes.
We found something very trivial contention. Therefore, we ask the other side.
I'm sorry.
That civil suit has been dismissed. It has not been restored. Yesterday, I checked the website of Madras High Court, my lord. Second appeal.
This order cannot be passed without hearing a person.
My lords, may I then only invite my lord's attention to 78 HR and CE Act and
no, please.
Joint Commissioner Suo Moto has power to initiate action.
Maybe, but that doesn't mean that the writ court exercises that power. Cannot step into the shoes of the commissioner. And commissioner also may have so motor powers. The commissioner also will give a notice to the other side before it takes.
Let then my lords may
we simply set aside this order.
Let us be parties, that's all.
And let them appear and do whatever they want.
Let it be decided.
That it cannot be done ex parte.
Then direct the High Court to hear them and pass.
Correct. Obviously. What else am I saying? I'm not saying anything.
We direct our impeachment, my lord.
Right.
We file a respondent number 2, the commissioner.
You agree with that or you want to contest that?
They are hand in glove, my lord. That is my submission. Because they have not taken.
You are there to check them.
They don't do
right
that. That's why I am before court, my lord.
Right on. Leave granted. We are inclined to set aside the impugned order without examining the merits of the contention. Merits of the contentions raised by both sides, as it is accepted that the directions given in the impugned judgment dated 18/6/2018 was passed without hearing the present appellant. namely so and so. Stop. Next page. Accordingly, we allow the present appeal and set aside the impugn judgment to the 18/6/2018 with an order with an order of remand to the High Court to decide the writ petition number 14031 of 2018 afresh without being influenced by the earlier order.
After
So
repeating us as parties,
the respondent, the appellant so and so will be implemented as a respondent to the said petition by the writ petitioner. Stop.
Your Lordship,
Cut short delay.
it will say.
It will be implemented as a respondent to the said writ petition. Stop. Amended memo of parties will be filed by the writ petitioner, who is the respondent before us. Respondent number 1 before us within 10 days. Next page. To cut short delay, parties are directed to appear before the High Court on
Lord, may I say?
14th of May 2025.
In the meantime, let us file our counter.
14th of May 2025, and a date of hearing will be fixed. It's not. It will be open to the present, to the applicant before us to file his counter affidavit within 6 weeks from today.
May I make a humble
14th
submission?
May, I am informed, my lord, the court may be closed for summer vacation.
When is it reopening? When is
June,
it
my
closing?
No, from May 1st it is closed. Your Lordship may fix it in June sometime, Lord, because May probably is closed.
Okay. On 3rd of June,
I have a humble submission on the order, my lord. Today, what is?
the interim order, once the order is satisfied, there is no interim order required.
Not at all, my lords. I'm making a different submission, my lord. The appellant's son has now become the hereditary trustee. So, my lord, instead of appellant, may say the hereditary trustee of the temple, my lord.
Yes.
Because there is a change.
We have also moved an application for that purpose.
Okay. The appellant stroke hereditary trustee.
Trustee, yes.
So, you give the name of the appellant stroke hereditary trustee.
In fact, my lord, our application for a substitution.
For substitution, that has to be allowed. Okay, then application first we say application for substitution of the appellant is allowed. And then you say in the later portion of the order, we have given the name of the appellant. Give the name of the appellant as given in that application for substitution.
Grateful. Grateful.
That's item 4. I appear for the petitioner, Lord. The decision to change the location of this ITI college from village Ticket.
Now it is already constructed, everything is done. And 27 trees were cut.
Lord, Lordship has.
You also came in after a long time, after 1.5 years.
What I have been informed is that perhaps it has not been completed and constructed.
No,
Because thereafter also, Lord, the government changed.
22, they filed an affidavit, it's constructed.
20, yeah, they said that it will be completed in 22, but.
But you came in much later. By that time, trees had already been cut.
Lord, as per the earlier procedure.
In view of the counter affidavit filed, we are not inclined to proceed further in the matter, and hence the special petition is dismissed.
Yeah.
There's no counter affidavit filed in this matter, Your Lordship.
1
Notice was
minute,
issued.
please. 1 minute, please. Who's appealing for the content? That's already supposed to. Served?
Yes. They have.
And what has happened is the illegal construction there.
That construction has already been completed.
So somebody is staying there. And is there any regularization scheme?
Yes, Your Lordship. All those documents we have already provided to the authorities.
Is there any regularization scheme? So leave granted. One appears for the respondent despite service. They have proceeded ex parte. Next page. The impugn judgment dismisses the contempt application filed by the appellant or alleged defiance and willful disobedience of the order dated 13/9/2020, 3/9/2020, passed in petition number 14662 of 2020, titled so and so. Page number, that order is at page number 15.
15 to 19.
First off, next page. The contempt petition was dismissed on the ground that it is barred by limitation as per the period prescribed under section 20 of the Contempt of Court Act 1961. Stop the short, next page. The short argument B of the appellant is that the court lost sight of the order passed by this court, holding that the period between 15/3/2020 to 28/2/2022 should be excluded in view of COVID-19 pandemic. Stop. Next page. That being the position, we have to view that the impugned judgment is unsustainable. Stop. Accordingly, we set aside the impugned judgment and direct that the contempt petition may be heard on merits. Stop. We have clarified, we have not recorded any observation on filing on merits, or even on the question whether or not the contempt petition would be maintainable. Stop. The appeal is allowed and disposed of in above terms. With an order of remand. Stop. We clarify, this order should not be read as expressing any opinion on merits. All pleas and contentions are lifted. Next case.
Item 6.
Have you paid the money or no?
My lord, I spent in jail 45 days, 50%.
So, but then you pay the money also.
My lord, nothing. I vacated the premises. In fact, if my lordship for a moment.
What do you want?
My lord, not even a single rupee paid towards the decree. After his father expired, my lord, he steps into his shoes and makes a submission.
Okay, but then tell me, is contempt maintainable? How is contempt maintainable?
My lord, may just
file an execution.
My lord,
is the degree in a civil suit?
My lord.
Execution is pending, my lords. The
possession is. Your conduct is bad. You want don't argue.
My father was
the more you argue, you more problem you're going to get into.
I understand, my lords. My father was the judgment.
Lord, just two facts, my lord. In the execution proceeding, my lord, he files an objection through one of his companies where he has opened his office on the same property.
Fine, then throw him out. He's been thrown out.
My lord, it's not so easy. My lord, one of his companies gets bankrupt. He writes to the RP, please get the warrants of possession state. That letter is on record, my lord. So he gets the execution state. Now in the RFA, he appears.
Fine, but the orders are passed by the court, no?
Please, my lord.
So your execution is pending, recover it. Where's the breach of undertaking given by?
Kindly see, my lord, the two orders that the court has found, my lord.
Okay,
three separate courts have found him guilty, my lord.
Okay, let's see those.
My lord, may kindly.
Because at that time, he was not even vacating the premises. Is that correct?
He was sitting in the property.
Correct. So therefore, the court had to use a stake to get him out.
But when he is convicted, my lord, at that time the possession was given. But my lord, his conduct is writ large. You come to court, lie to the court with.
Let's see the undertaking.
Please, my lord. My lord, the order is at page, annexure P10, page 234. My lord, may see para 23. Second last page of the order. The counsel for the legal heirs of the appellant defendant number 1 states that the legal heirs could not deposit without. I'm so sorry. My lord, may I read para 23 onwards?
Yes.
The counsel for legal heirs of the appellant defendant states that legal heirs could not deposit without coming on record. The legal heirs of appellant cannot on the one hand continue in possession and on the other hand wriggle out from the liabilities of the deceased appellant. The counsel for the legal heirs appellant states that Mr. Ankur Jain, who is the petitioner here, my lord, son of the deceased appellant, is personally present in court and undertakes to this court to within 2 weeks deposit 25% of the decretal amount with up-to-date interest thereon, and within 4 weeks deposit another 25% of the decretal amount with up to the date of interest therein. Mr. Ankur Jain, identified by the advocate, has been cautioned of the consequences of breach of undertaking given to this court.
But he has been in for 45 days now. And it's a civil contempt.
I bow down, my lord.
He's been in for 45 days, maximum 60 days.
Maximum, my lord, is 6 months.
6 months.
6 months.
Right.
But
6
in
months.
this case, I leave it to my lord. As an officer of the court.
That he's already undergone. And does he have money? Does he really have money? Or he's bankrupt?
Bankrupt, I am declared bankrupt now, my
lord.
And my lordship can have page 282 for a minute.
I'm asking you.
My lord, may kindly appreciate a person coming to court and saying, I will deposit 50%.
I've understood. Does he have money?
Nothing, my lord. He files his bankruptcy right after. That's what I'm saying. So
we are dismissing his appeal, but as far as the finding with regard to contempt is concerned, for reducing his sentence to the period undergone because he's already done.
Just one submission. There is today a blemish of contempt on my head.
Yes, you will have.
The moment my lordship can have page
You're very lucky.
It's one page.
You want us to increase the sentence?
My lords, I'll not argue of that. 282 for a minute. For a minute, my lords.
This undertaking, if given.
My lords.
1 minute, please.
This was.
When the day when you gave the undertaking, if you knew you will not be able to pay, then that undertaking is you're walking on the pot sword.
My lords, I was
you are taking the pot for a ride. That is not acceptable.
My lord, subsequently I
was released. I will not go by that. But when
Honorable High Court, 282 for a moment. 282, page 282. Just one para. 282 para 7. That's all. I'll not argue after that. My lord, page 282, para 7, the stay is vacated.
Yes.
I move an application for modification. Just see the order, para 7. It is only 1 year after this order, the contempt is filed. Look at para 7 for a moment.
Yes.
This
is a continuing law.
This court is not satisfied with the reasons assigned by the applicants. Appellants for non-compliance of so-and-so. Accordingly, this court is not inclined to extend time for deposit of decretal amount. However, the consequences of not depositing decretal amount in terms of so-and-so should be seen at the stage of final argument.
Okay, fine. Sorry. Right on. I mean, first thoughts for the parties. We are not inclined to interfere with the full judgment. So far as the appellant has been held to be guilty of contempt of court. Full stop. To this extent, the appeal is dismissed. To this extent, have we granted the appeal is dismissed? Full stop. However, on the question of quantum of sentence, we inform that the appellant has already undergone simple imprisonment for a period of 45 days. Subsequent, it is also stated that the appellant has been declared to be insolvent as he does not have money. Has been declared to be insolvent. Stop. How much was the fine imposed? 2,000.
2,000.
Fine has been paid?
Yes.
Just stated the fine of rupees 2,000 has been paid. Stop. The facts of the case, and and also noticing the fact that the appellant did surrender the possession. Go after some difficulty.
No, my lord, he did not. He handed over the possession to the RP. We had to go to the NCLT, my lord. This person did everything, my lord.
Just strike the last. It is to be also noted that the appellant is no longer in possession of the suit property. So, in these circumstances, we reduce the sentence to the period undergone and fine of rupees 2,000 as directed.
My lord, may I just make one small request, my lord? Appellant through his companies has filed objections in the executing court that we are also in possession because our registered office is this.
None. I have filed none.
He should
just
even
listed
undertaking
as a
even
Before that, you just record. Before last portion, they have said that they reduce it. It is on a question being put on the submission made by learned counsel for the respondent. It is stated by on behalf of the applicant that the companies in which he has the company of which he has been a promoter or shareholder or a director would not press any objections, if any, filed before the executing court, claiming right title interest in the property.
None have.
I'm so grateful.
None have been filed.
Deeply obliged.
Obliged.
In view of the aforesaid position, the party accept the present appeal and reduce the sentence awarded to the period undergone and is 2,000 as fine.
Obliged.
The appeal is allowed and disposed of.
Please, madam. I beg to appear for the petitioner my lords in this matter. Please, madam. Please, madam. We get dates also. Please, ma'am.
Yes, please.
As this issue, the issue in this matter pertains to the rights of the vendor, my lords. Even he had applied.
1 minute, please. You have subletted.
My lord, this is most unfit of the. My lords, no, my lords.
You have subletted.
My lords,
It's quite normal and common.
and he has not even expressed that he has not even challenged that order.
You are not there when you sell Pani Puri, must be very good quality. But
It's the only source of livelihood.
no, what source of livelihood you have subletted?
Now, Malaj, may kindly have a look at Malaj. I'll not argue, Malaj. Now, Malaj, there is this Street Vendors Protection Act in place.
Whatever it is.
Even Malaj applied in that. He has not even applied for that. Malaj,
No, you have clearly said the photographs speak for themselves. Just look at the photograph. If the counter affidavit is somebody else. Who is this person? Who is this person in the photographs who's selling?
Malaj, these are my family members, man.
What's his name? What's his name?
Malaj, I'll file. Malaj, this.
You have the opportunity to file the flag with this council.
Yes,
why did he not file the rejoinder?
Malaj, because Malaj, this is coming for the first time, Malaj.
I'll file for the first time. You got to stay and you. This was filed in July 2023.
Yes, stay of a non-existent order. File it within a week, Malaj. Stay of a non-existent order. That order is not in existence. Because these are based on motivated complaints, Malaj, by the restaurant which is just. This is the only source of livelihood for me, my lords. I'll just file my rejoinder, my lords. In that, my lords, I'll also.
We are not inclined to interfere with the acute judgment, especially.
My lords may allow me.
Watersheds stands with it.
My lords may allow me to.
Our dismissal of the special petition would not have any bearing on the application, if any, made by the petitioner for awarding a fresh hawker's license.
My lords, under the this.
That's all.
I'm grateful, my lords.
The Lordship, this is a matrimonial matter. Court has previously directed the petitioner to deposit 1 lakh rupees. He has deposited money to registry, but since then, for a month or so, the wife has been living, cohabitating with the husband. We have been unable to contact the wife.
They have rejoined.
No, minute. Mediation was filed.
No, she's saying that wife is living.
She has been just staying with her husband. We have been unable to contact her.
So you are paying for the husband?
Wife.
You are for the husband?
My lords, I am for the petitioner, my lords. I will get the latest position, my lords.
You also don't know whether she is back with him.
It's not correct, my lords. I have telephonic instructions that the suit for partition is pending. She is not, they are not living together, my lords.
They are not living together?
No.
EP dues were 6 lakhs and all. You deposited only 1 lakh.
1 lakh.
The money may be given to her if she is not living with him.
Yes, let's.
Earlier also there was settlement.
Let's.
She went there and then thrown out. All these cases come to, if the cases comes to a peak level, and then they.
Would have to make to you?
No.
There is a direction, my lord, to deposit 1 lakh rupees, my lords. That was the reason.
Rupees 1 lakh deposited by the petitioner will be paid to the respondent. Stop. Let me transfer the respondent along with interest accrued if any. Next page. It's stated on behalf of the respondent that the petitioner and the respondent is now residing with the petitioner. Stop. Let transfer the parties to verify. Let transfer the petitioner to verify this fact. Reinvest in the week commencing. First of July. Since 5th of May 2025.
In item 9, my lord, if I may mention, I am appearing for respondent number 13, my lord. I am one of the main contestant party, my lord. The AOR has designated as a senior advocate, my lord, in this matter. So I am seeking some time, my lord, to.
What is this? Is it infructuous now?
No, my lord, time for the petitioner.
What is it?
I would also indicate one aspect.
Why is it absolutely infructuous?
There's a statutory enactment in that area, 1901 statutory enactment, the Chota Nagpur Tenancy Act. It prohibits, my lord, sale completely of lands which are given to the scheduled castes, scheduled tribes, etc. Because there is a likelihood of fraud, there's a likelihood of them being taken for a right. There is statutory violation is one of those aspects which I point out. Well, the other aspects are all natural corollaries of this basic statutory violation. Lordship, if you would notice in 2017.
What I can make out is that the land is already given to a public sector undertaking. The lease is given to a public sector undertaking. So the other lease now is today infructuous. It's all everything is infructuous.
Nothing has been acted out. It's very
No, it will be. I think the counter is very clear.
Lords, there is a government report. I'll show it to your lordships. But I mean, I've just been made the advocate on record. Now the earlier advocate on record graciously accepted that he be removed from on rolls.
Because you would have possibly found something.
No, that's. I mean, may your lordships.
But raise question now if the third party has come in.
Let's.
If there is
a larger issue of
what is the issue decided in the impugned judgment? It's a very short judgment.
Impugned judgment did not go into the matter. The impugned judgment cast aspersions on me, said that I'm not a genuine public interest litigation. Correct. This court initially, while it issued notice itself, said that there's no question of genuinity because there's so many other people who had come with the same issue and it is not me who had come. Today,
No, there's a decision of this court dealing with Rectificator, including constructive
this court.
Rectificator and PIM.
I don't. That doesn't fall on me, my lords. My genuinity was accepted by this court when your lordships issued notice. I'm saying it on.
That's not the, that's a private side. That's not that final. Please don't.
No, my lords, I'll just indicate.
But what is left in this matter?
These, my lords, there is rehabilitation, there is environmental pollution, there is, my lords, livelihoods which have been affected, and these my lords, the transfers are just the starting, my lords. Criminal proceedings which have been initiated against these people are going on. That's one aspect. Secondly, my lords, what's most important is that the governmental report was called for at that point of time. That report is entirely in my favor. Because that report says that yes, these transfers are completely non-est in law, ab initio void under the Act. Well, if your lordship see this Act, I'll just show you.
Question of mining operations. These are questions of mining operations. They've given the lease to a third person. Earlier there was another company which was dealing with it.
The company has been blacklisted. That's one aspect. Milords, I will not even go into it. The basic is that the transfer was illegal, Milords.
To occupation of the mines, who's doing who's got the lessee or whatever it is of the mines? Who's appearing for them? You are appearing.
My lord, I am for 13, my lord. My lord is right to the extent, my lord. The mining operation has been given to some other company. This is
So
where
you entered into the agreement.
I am on 13.
What did you do with the land? You also entered into agreements with these people.
My lord, I need
Are 13 and 14. Both
yes, my lord.
What did you do with the land?
My lord, as far as I was, my lord, yesterday I got the brief, my lord. So far as the AOR is concerned, is been designated to the senior advocate. But so far as, my lord, the counter is concerned, I was just looking into it on page number 5. It has been clearly stated, my lord. Page number 5, paragraph number 6.
Yeah.
Counter affidavit of respondent number 13, my lord.
Yeah.
It's on number 13.
Page number 5.
Page number 5, my lord. Paragraph number 6.
So page number 5 begins with para 12.
Para 6, my lord. Page number 5. This is the counter affidavit on behalf of the respondent number 13. 13.
Yes. Page number 5 begins with paragraph number 12.
That would not be the counter of respondent 13, my lord.
This is counter of respondent 13. This is the file cover.
13 and 14 jointly filed a reply.
The 13 and 14 have jointly filed the count.
Yes, my lord.
Reply affidavit is Rajiv Kumar Singh, who's the deponent.
Yes, Rajiv Kumar Singh, my lord. Actually,
It
it is
filed
there in
on
the
behalf
secondary
of
petition, my lord.
13 and 14 both.
Yes, my lord.
Paragraph number, page number 3 is paragraph 12.
No, my lord. Page number 5, paragraph number 6, my lord.
Let's I have got the page number. May I read it for him? When I want to know what falls out of it. Even though my humble submission is below.
There in the
Extensions of this paragraph are denied and the petitioner be put to strict proof thereof.
This counter of 13 and 14 together, which he's trying to refer to.
Yes. It's actually not a counter. These are the parawise remarks which have been converted. Because
That's right. Your lordship are right. Your lordship are right. Milords, this is a 2017
And the Supreme Court only parawise remarks are filed by adding at the top and the bottom as well.
May I just indicate one aspect? The High Court has not gone into any of these aspects. There was a commissioner report in our favor saying there were so many anomalies. The statute has been violated in entirety, which is the beginning of it.
No.
Let's the digitalization of these matters have not happened.
My lord, I am reading the reply in the main special leave petition. My lord, might have the reply in the supplementary affidavit, my lord.
Okay, this is a reply to the compliance.
Yes.
Reply.
So I am reading the reply of the main SLP.
That main affidavit, page number 5 is reply affidavit on behalf of respondent number 1314 to comprehensive affidavit filed by the petitioner.
Yes, my lord.
That's the one.
Paragraph number 6 is mentioned, my lord.
Just see from this.
My lord, if I can give my brief to my lord.
No, not this.
This is not the one.
My lord, if I can give my brief. This is there in the main assignment. So, my lord, may kindly look into it only. Page 5, para 6, my lord.
It's not in the, I've seen in the index.
To this, after the mines have been taken away from you.
Yes, yes, my lord.
Does it survive?
Yes, my lord. This is what I am saying.
Lands are given back to them.
Right. Yes.
Statutory violation goes to the pector.
But that is separate issue.
Lands back with the schedule.
Looks, the tribunals have not been
No,
rehabilitated.
please, that you'll have to then raise a separate tree. Whether you see, that area, if the government has excised its right to the land, then you'll have to challenge that.
Your lordships may just crystallize what's
that
issue.
What I'm saying is, if the government has acted upon this,
The government's itself report, my lords. The report is on record.
Just one. Which page is the government's report?
That's page number 30 of the original SLP paper book. N.K. Mishra IAS.
Yes.
Lords, this is a comprehensive report.
Just one. Okay, if you have any case, we'll permit you to file a fresh one on the question that this land does not belong to the government.
Such a transfer ought not to have. I apologize.
Eminent domain normally applies. Eminent domain normally applies. And the difficulty with the tribals obviously is they will not be ever having any letters or transfer deeds in their favor, sale deeds or transfer deeds in their favor. But then in these cases, the government has some schemes under which they decide whether the doctrine of eminent domain will be used in a particular case or not. That's a problem because as far as forest dwellers are concerned, tribals are concerned, in 1800 to 1900s, who will give them a title deed? So that becomes a problem. Forest dwellers' rights is a problem. Now we have forest dwellers' rights. So neither will you be able to transfer, but the government will claim it on the basis of eminent domain. So you'll have to challenge that.
I just tried to reply with my limited understanding. That's eminent domain, yes. But when the statute says a transfer has to be done with a registered deed, these are done through agreements. The challenge is on that statutory violation. This particular act, my lords.
Please, 1 minute. We don't, but provided you first show your right on the land. How will you show your right on the land? Either under the Transfer of Property Act, it has to be by way of a deed. You won't have it. There's no question. So you'll have to build up your case entirely differently.
I'll just answer your lordships. They would have a right. That's why because if it is an acquisition, this is not an acquisition. Only an acquisition is possible under what fell from your lordships. The exercise of the state's right of eminent domain. Right would not be the right word. I apologize. The state's eminent domain over this whole properties. If it is an acquisition, what fell from your lordships?
Domain where there is no title of land with anybody, it falls within the government.
Here, my lords, the government depends upon their title. They say that, okay, you have title, I'm getting into an agreement with you and takes over the land through an agreement. We challenge that because, you can perhaps...
No, but does the act bar government take over into? taking over
The
land.
government bans
No,
registered deeds.
No, the government may ban deeds with private parties, not with the government.
Here, the government facilitates a private transaction. If they actually exercise their right of eminent domain,
There are exceptions to it. If the government has followed the law.
they have not. They have not.
One minute, please. There are restrictions on transfer to private persons. So, okay, government did not exercise the power of or the doctrine of eminent domain. They accepted you are the owners, but they have facilitated transfer of land to A, B, or C.
Your Lordship, the standing counsel is appearing virtually. Your
What is who's the standing counsel? Just asking.
It's Rajiv Shankar Trivedi, Your Lordship.
Yes, Your Lordship.
What's the factual position?
Lordship, the factual position, we have actually filed one status report way back in the year 2019. Now, the current situation, Your Lordship, will have to take an instruction on that what is the current scenario. Our reply which we had filed there is there on page number 1440.
1440.
Yes, Your Lordship, this is 1444. And Your Lordship, so far as the scheduled tribe people are concerned, Your Lordship, we have specifically stated that the Santhal Pragna Tenancy Act, Your Lordship, is categorically provides that if a scheduled tribal person is taken out of possession without authority, the commissioner, the DC, the divisional commissioner has ample power to exercise under the act, Your Lordship, to restore him in the possession if the same has been done without following the due process of law or in any other illegal manner, Your Lordship. So all those authority, they are already there in the place, Your Lordship, and each case has to be dealt on its individual basis on its own, Your Lordship. And the entire reply is there, Your Lordship. It was filed in the year 2018. So far as the current status is concerned, Your Lordship, we require some time to get instruction on that.
So, no, you are accepting therefore the case made out by the petitioner?
No, Your Lordship, we are opposing that, Your Lordship. We are opposing that.
When you said there is a restriction on transfer, then you accepting the case made out by the petitioner?
No, I'm not saying that, Your Lordship. The petitioner herein have made of 4 or 5 set of allegations, Your Lordship. We have denied.
Your commissioner's report, page 30, what was pointed out, 29/1/2015. At page 35 records that the transfer of land in favor of Usha Martin Limited was in violation of the provisions of the Chota Nagar Tenancy Act. How are you opposing that you've taken?
Your Lordship may
Learned Counsel for the state of Jharkhand will ascertain the correct position and file status, correct position in today's date and file status report. Up-to-date status report within 3 weeks from today.
Lordship.
Relist in the week commencing 28th of July 2025.
On a small request, would your Lordship be gracious to permit us also to file documents as regards the
petitioner is also permitted to file additional documents by moving an appropriate application.
Most grateful, Lord.
Much obliged, Lord.
Yes. So, Raju, what is the position?
Predicates offense. Even as far as the first predicate offense is concerned, it is not cost against all, it is cost only against one person. Therefore, the predicate offense survives. Subsequently, Your Lordship in Pavana Deputy has taken the view that unless the entire predicate offense goes, the PMLA offense doesn't go.
But the second one is also subject matter.
Second one is also subsisting. Second one will have therefore
There are subsequent developments. I'll apprise you. And so there are two FIRs originally, 36 and 37.
Yes.
In 37, my lord, I was discharged. The order of taking cognizance was quashed. The other accused in 37 were public officials. Two of them, government refused to grant sanction for prosecution, categorically taking the position that there was no loss to the exchequer. The third public official, the proceedings against him have also been quashed. May I just hand over a copy, my lord? So, my lords, insofar as 37 is concerned, there remains only one accused. The charge of conspiracy certainly can't be brought against him. He's a lone public official.
I'm not.
All other public officials gone.
I'm the PMLA offense.
May I just, Mr. Raj, if it will permit me. The other my lord matter, 36. Also, one of the public officials has now secured a quashing. That order, my lords, I'm also handling.
That's not relevant. Well, there are two things which are there.
Yes.
One, there are two predicate offences.
Yes.
You can't quash it, the EC, only on the ground that one predicate offence is no longer applicable. It has been quashed. The other one will continue. Number one. Number two is that as far as other cases, in this case also is concerned, the prosecution was quashed only against them. One which was quashed was only against two of them. Others it will continue.
No, that's what I'm saying, lords. Insofar as the other two are, there are total 5 lords. Against 2 lords, government has refused to grant sanction, saying there's no loss to exchequer. So the prosecution can't be sustained against them. Against the third public official, lords, I have just passed on an order where against him also the prosecution
This is the second case or the first case?
The second case where I am successful. So in the second case where I am successful, my lords, my respectful submission is the proceedings cannot survive against anyone. There were total 5. Against 4 of them, they do not survive. There is one person who remains, my instructions are, that person is also now filed for quashing. Against that individual, there certainly cannot be a charge of conspiracy that can be brought out. There can't be a single lone conspirator. 120B charge cannot be made out. In the other case, there were a total of 4 accused. One of the public officials has already secured a quashing. I have also moved for quashing, lords. That is at the final stage.
But that's irrelevant.
Lords, if I succeed, there.
No, if you succeed, it's something in future. The matter
is at the final.
The moment you accept that the second FIR is still subsisting, it's good enough.
May I then respond on merits? Their investigation and their complaint was predicated only on the second one where I was successful. May I just indicate that straight away? Your lordship will see the complaint that they have filed. 27th of March, sorry.
Which page?
The complaint is dated 16th of October 2017, my lord.
16th of
October 2017 is the complaint under section 45.
16th of October
2017. That your lordship will find at page 124.
Yes.
The narration of facts, your lordship will see it starts at page 135.
Yes.
Where from para 5A.1 till 5.8.23, they deal only with the predicate offences and the investigation that is carried out by the vigilance.
Yes.
The entire narration of events for the investigation that is carried out by the vigilance department is only qua FIR number 37, which is quashed against me. Then your lordship will see their independent investigation. Their independent investigation is at page 136.
Yes, 136.
136 is the investigation that the Enforcement Directorate carries out.
Yes.
Kindly see 5B.1.
Yes.
On the basis of FIR number 37. This is the one where I am successful.
Yes.
And the case where, my lords, only one single accused survives today. 5B.1 till, my lords, your lordship will come straight away till 5B.10. It is entirely a discussion on FIR number 37, where I have been successful.
My learned friend may read 5B.1. It's not confined to 120B, but there are other sections.
No, I have been discharged of all offences. The order taking cognizance of all offences have been quashed.
5B11.
ACIR mentioned based upon 1 FIR, 2 FIR.
Kindly have a look at
5B11.
11.
The one para they write.
11. Page 140.
I'm not disputing. Let's see, lordship will see what they write. The proceeds of crime that purportedly arise from these scheduled offences are only qua FIR number 37. Your lordship will kindly permit me to place 5B.10 and 5B.11. 5B.10, my lords, may I read? During investigation, it was seen that the coal was lifted at subsidized rate by measures so-and-so, that it is me, and not delivered to the intending MSME units. As the e-auction price of the coal is much higher than the price by OCCA for supply of coal to MSME units, it appears that measures so-and-so got all the pecuniary gain amounting to rupees 1.35 crores and causing equal loss of amount of loss to the government. This is FIR number 37, where, my lords, on merits I have succeeded. The categorical finding, my lords, of the High Court is that this charge on merits is not made out. Then your lordship will see para 11, that on the basis of FIR number 36, ECIR number so-and-so was registered to investigate the matter under the provisions of so-and-so, so-and-so, so-and-so. While conducting investigation, the statement of the persons were recorded under section 50. No mention at all of any pecuniary loss arising out of this particular FIR.
No, they have mentioned about that.
Last two lines.
135 they mentioned.
Last two lines.
They have already mentioned about the pecuniary loss.
Last line is merged.
Will my lords kindly see the charge sheet?
The entire para.
Correct. This will not be correct because they have mentioned about 135 crores and then they have said ECR is merged. So this cannot be sustained. Of course, other things will.
36 also, my lord, the public officials have now secured a quashing in their favor.
Maybe.
So, my lords, how will a charge of conspiracy be made out against me?
Pardon?
The public officials have secured a quashing against themselves.
But your quashing is still.
No, 120. I have been roped in at 120B.
1 minute, please. You're the only person left.
There are 2 more persons left.
Let's see.
All of them have filed quashing.
Look, it's also possible. Let's also take it. Suppose they are not able to find out the actual public officials, or the public officials have died, or they are untraceable.
That's not the case.
120B still can be.
No, but that's not the case. That's not the case of the prosecution. Because may I just indicate on merits what the case is?
We cannot go. Look, we are not saying that you may not be entitled to benefit of quashing at a subsequent date. We are just testing it either on the date when the order was passed or today's date.
May I make a suggestion, my lords? My quashing petition is at the final hearing stage. It's listed on 15th of April. Will my lords call this matter after that? If I am successful, my lord, nothing will survive. In both the cases, my lords, I would have secured a quashing. The continuance of this would be a complete abuse of process, my lord.
No, yes. You may not succeed still. May not succeed still. 1 minute. For the reason that you may not even be involved in the predicate offence. But you may be involved.
No, I see what is falling from your lordship. But I have been successful in the other case on merit.
You may not succeed. But to stay the proceedings like this or quash the proceedings when the other offence is still.
All I am saying, lords.
You're on bail.
All I am saying, lords.
Are you on bail?
I was never arrested, lord.
You were never arrested.
Lords, may I just say?
Proceedings is different. If you don't succeed, the consequence, even if you succeed in the quashing proceedings, it will depend upon the nature of the order passed.
May I just indicate straight away what the nature of the order passed was? Lordship will kindly see paragraph 14, my lord, at page 156. The finding of the High Court is that, my lords, there is no pecuniary loss to the government. The entire case that was set up by the prosecution was that there were certain fake MSMEs to whom, my lords, coal was supplied and no money was forthcoming. The finding of the High Court is that the money actually was received by the government.
That is
the case.
One minute.
Yes.
1 minute. You see, the issue was
Yes.
that the coal actual market price is much higher.
No.
The market price is much higher, and therefore, in order to gain pecuniary benefit, coal was supplied to MSMEs. Money was certainly paid. Because if the money was not paid, it would have been a different kind of fraud.
It would have been a different fraud.
It
That was the original case.
But therefore, what happens is, what they are saying is the money laundering will take place or the crime is committed. Is a difference between the price paid and the actual market.
May I just answer straight away? This policy was made in 2007 for supply of coal to MSMEs, whose annual coal requirement is less than 4,000.
We are not going to the merits of that.
Let me just straight away.
We have a
allow
very
me 2
simple
minutes.
proposition before us.
Yes.
There are 2 FIRs, one is quashed, one is still pending. How can the High Court?
My straight response to that, my lord, is this. In that FIR, my lord, qua the public officials, there is a quashing. My quashing petition is pending.
That is something different.
Will my lords kindly have it after? If I am successful, your lords.
No. We are not keeping it pending for that purpose. That if you succeed, you go there. Look, this judgment ultimately, even on the date when it was passed and today, is unsustainable. We are looking into the future and saying it may be unsustainable, it may be sustainable. Why should we do that? In case you succeed, you go there.
Categorically says, my lord, if
No, and there's a catch in your argument also. Suppose even if the public servants are left off because of they have not been able to pinpoint the actual public servants involved, and there could be third parties involved, persons who have been implicated but not.
That is not their case. That is not their case.
That will be the case of the court.
That is not the case of the prosecution.
Not their case.
The case of the prosecution today is that there are only these four public officials involved. Two of them, Lord, government refuses to grant sanction, saying there is no loss to the government.
Correct, but that finding is wrong.
May I just? It's not been challenged by the prosecution,
No,
either by
but
evidence or by the ED.
where will they question the sanction? We'll only go on to that fact that there's a second. To 15 days.
Kindly have a look at one judgment.
I be aware of the law. What is there?
Same thing, it has to result in acquittal or discharge of all the accused.
I agree with you on that. I've said even there has to be acquittal or discharge of all the accused. I agree with you.
Therefore, if the predicate offence survives, there can't be a discharge.
Correct, they cannot be discharged. You're right. But he's saying that if possible he gets out on merits himself in the predicate offence.
I see something off the cuff, without allowing me to go through it. So
Let me file an affidavit. I'll file it.
You should have placed it by way of an affidavit.
I'll file an affidavit, my lords.
Yeah, I have it after 15 days. The relist in the week commencing. May 13th of May 2025.
Great.
That's good.
Well, sir, in
the substitute company which can give the valuation.
Well, sir, in support of my application, I just have two small submissions.
One, you have to change the valuer.
And second is, my lord, there is an observation in the last order which says that the valuer should consider the reasons for the the respondent not being.
No. What modification you want?
My lords, may just see the last order of 9th December. My lords, on the second page, there is a second para which says, while undertaking the aforesaid exercise, the valuer will take into account the pleas and contentions of the respective non-applicants resulting into non-subscription of shares. Valuation will be undertaken keeping all aspects in mind, including shareholding pattern as it existed. My lords, my humble submission is that let this part be taken care by the court or the mediator.
No, nothing to it. Valuation report will undergo a change. They make different valuation. They make different valuation of the shares depending upon A position, B position, C position.
Absolutely. My lords, then my humble submission is that let the guideline be given that the valuer can take into account the year 2019 and the current valuation. That will...
No, we are not saying anything. We'll say the valuer may make valuation for different years as deemed appropriate.
2 years are sufficient.
We are not going into, except 2 years is acceptable.
No, Your Lordship.
2 years is not acceptable.
In fact, Your Lordship, in the last hearing when the valuation...
Give us the name of a valuer.
Your Lordship, one submission, the company has 1.8 crore profits, no dividends being given. They can pay Deloitte.
No, 40 lakhs is quite a lot. 40 lakhs is quite
40 plus GST, my lord.
No, it's quite a lot.
Open-ended. So
they can't spend 1/3 or 1/4 of their income in that.
But no dividends being paid to us for...
That'll make a difference. But tell us a valuer, both of you agree?
Yes, ma'am. In my new application 86606, I have listed out the number of valuers in Hyderabad, my lord. My lords, may come to page 10 of that. Page 8 of that, my lords. 8 of my new application. This is 88, that's 38.
So, okay, you select one out of this list.
These 6 are all available in Hyderabad, my lords.
I'll have to seek instructions with regarding the same. I'm okay with anything, Your Lordship.
In view of the amount being demanded by Deloitte, also, we feel that a new valuer is required to be appointed. The petitioner has given a list of valuers in IA number 86606 of 2025. And transfer for the respondent will select a value from the said list or may give another list to the counsel for the petitioner within a period of 7 days from today. In case another list is furnished by the respondent to the petitioner, it will be open to the petitioner to select a value from the said list. Next question. In case the petitioner and the respondent are not able to decide the valuer, they may approach this court by way of an application, which will be filed in a period of 15 days from today. Within a period of 3 weeks from today. Relist to await the valuation report in the week commencing 4th of August 2025. Next paragraph. The valuer, it will be open to the valuer to value the shares on different dates as may be required in necessary.
My lords, may consider
including 2019.
My lords, the mediator in this case has taken about 6 months but has held only one meeting as yet. So would my lords consider an alternate mediator, maybe a former judge of Supreme Court?
Who's the mediator?
Actually, the mediator has said that since valuation process is under...
Who's the mediator?
Mr. Prabhakar, he's a senior counsel in Hyderabad.
No, that's fine. We don't change mediators like this. In fact, I'm a little surprised at your application. You're trying to wriggle out. That's not done.
No, I'm not wriggling out. My lords, and see the conduct of the respondents meanwhile.
No, you made a lot of allegations now. Let the matter go on.
Obliged.
You are the one who will have to shell out the money.
Well, in this case,
1 minute, please. You're the one who will have to shell out the money.
I'm most grateful.
We have the other terms and conditions of the order dated. What's the date of the order?
9th December.
9th of
December.
December 2024 are not interfered and will continue to apply. So you have 7 days time to select the valuer from that list. If you don't give him a list within 7 days, he will then select. If you can't agree, then you come to the court.
Highly obliged.
We appear for the petitioner, my lords. This is a challenge against the suspension of sentence where a 21-year-old boy died with 20.
Yes, please. You have not filed a counter.
Your lordship, I am appearing for street. She is for private response.
Why have you not filed the counter? You had entered appearance, you first refused summons, and then you entered appearance, and that was done way back in December.
Yesterday we are in the matter.
Okay, fine.
My lords, at the time of issuance of notice, the matter pertains to a 21-year-old boy being beaten by all of the 5 accused persons, and 22 antemortem injuries are there. And the reasoning for the death, as per the post-mortem report, as far as the examination of the doctor, says that due to asphyxia because he could not breathe. Now, with regards to that, there is a specific role allocated to each accused.
How long have you been inside?
I have been around 2 years, 9 months in jail. I was granted regular bail for a very brief period of time.
And after that, that was cancelled by the High Court, which was also challenged before your lordships, and your lordships were pleased to not.
How many accused are inside?
None of them are inside, my lords.
All of them are outside.
All 5 of them, and the conviction is for life, and they have only served up to 2 years or max 3 years, and 22 antemortem injuries, my lords. And it's a 2024 appeal.
If I may,
Not even half the sentence is undergone, my lords.
Your lordships, the cause of death as per the post-mortem report is that it is due to strangulation. My lords, if I go by the contents of the FIR also, there's not a single contention that I have strangulated or any of the accused have strangulated. The only
injuries on the body.
My lords, and my lord, specifically injuries number 11, 12 and 13 clearly shows that there was a lot of pressure on the neck.
My lords, but the case of the prosecution is also that it is only because of the beating with the sticks and everything. My lords, there's no case of strangulation which has been stipulated in the post-mortem report.
I'm sorry, we'll have to cancel that.
Grateful, my lords.
Lords, in fact, if we go by...
No, sorry.
Lords, in fact, if we, in my most respectful submission, Lords, if we go by
This case of conviction, the period undergone is very short. It's under 302, and look at the number of injuries suffered. There are pressure injuries also, pressure abrasions which defect, and somebody was, there was a pressure pot, and there's a pressure abrasion on iron cartridge also, everything. So that means somebody sat on the neck and.
Your lordship,
That is what the evidence also says.
statement of witness, eyewitness, PW 2 and 3, they have specifically stated that they sat on the chest of the deceased.
And even one person sat on the head of it with the stick. And a 21-year-old boy.
Right up.
5 people.
one last submission. If
Para 11 of the judgment practically seals the fate of the appeal.
Absolutely.
There's nothing left in the appeal after this kind of observation.
Having heard counsel for the parties, we are of the opinion that the interim judgment dated 11/3/2024, granting benefit of suspension of sentence to the 5, to response number 1 to 5. Recording that the trial court private side committed an error in convicting the said response under section 3 and 2, whereas evidence would suggest that they should have been convicted under section 3 and 4 of the Indian Penal Code should not have been made at this stage. Full stop. Notably, the punishment prescribed in Part 1 of the Indian Penal Code, Part 1 of Section 3 and 4 of the Indian Penal Code, may extend to life imprisonment. Explain. Homicidal death of, what's his name of the deceased?
Bharat Bhai. Bharat Bhai, minutes.
Bharat Bhai
Yes.
is undisputed and is proven by, is undisputed. Full stop. Ganpat Bhai, PW?
PW 15 minutes.
PW 15, Dr. Ganpat Bhai, PW 15, who was a doctor, has had conducted the postmortem, has identified as many as 22 injuries on the body of the deceased, which included injuries caused due to oblique pressure abrasions. Stop. The cause of death was identified as asphyxia. Which page is the cause of death specified?
Page 41 minutes.
Page 41 PM report. Serial number 23.
Asphyxia due to manual strangulation and smothering. Stop. How? Stop. This aspect of divergence in the postmortem has been highlighted in the accused judgment. Stop. However, in our opinion, the said aspect would require detailed examination in greater depth and detail, given the finding that there was oblique pressure abrasions on the neck and other areas surrounding the neck. And other surrounding areas. Full stop. Next page. The respondents 1 to 5 have undergone incarceration for periods between 2.5 to 3 years.
3 years, 3 months.
2, 3 years, 3 months. Including remission or without remission?
No, not without remission.
3 years, 3 months. Full stop. Next page. In view of the aforesaid factual position. In view of the opposite position, the impugn judgment dated
11/3/24.
11th March 2024 is set aside. So, respondents number 1 to 5 are directed to surrender within a period of 3 weeks from today. But in case they do not surrender, the state police will take steps in accordance with law to detain and arrest respondents number 1 to 5. Next page. The appeal is allowed and disposed, impugn judgment set aside, and the appeal is allowed and disposed of in the above terms. Full stop. We clarify that the disorder and the order of the High Court, which has been set aside, would not be treated as expression of opinion on the merits of the case. The appeal will be heard and decided on its own merits after examining the pleas and contentions raised by the counsel for the parties. Full stop.
Lordship may kindly direct the High Court to decide the appeal expeditiously.
It will be open to the parties to approach the High Court for expeditious disposal of the appeal.
Thank you,
Let this matter now go before another bench. We'll take time. I don't want to reserve any.
Lordships heard it at length.
Concluded by argument.
My lord, after I finished, your lordships, I told them you try to settle it if you can.
I can't. I'm not going to reserve it.
Lord, both of us have to try and settle it, not I alone. I can't settle it. My lord, my problem, I'll state what it is. Your lordship will recollect when I had succeeded. Thereafter, in the execution petition, I had succeeded both before the NCLT and CLAT. They filed an appeal. I'll just state it. No, I'm not asking my lords to take it up. I have a different my lord, I'm asking my lords for something else. It's nothing not to take. My lords, pursuant to the order, those shares were required to be registered in my name. They did not do so. I've succeeded in two fora. I filed an execution. Execution allowed. They filed an appeal. Appeal dismissed. Execution. When they filed consequentially against the execution, your lordship said we are going to hear the matter. Do not precipitate the execution. Yes. To which I said yes. My lord, I'm only making one request. Let them rectify the register, put it in my name. I will not transfer the shares and I will hold the shares. I will not transfer the shares. Because if the shares are rectified, I have a right at least, my lords, to act as a shareholder. I will not transfer it further. But surely, concurrent finding of facts.
Yes. Have I asked you any question? Why you answer?
Well, I thought.
Well, you want to answer without even.
No, I'm sorry.
Right on. To be listed before bench presided over by Honorable Mr. Justice.
My lord, I heard it at length, my lord. Those are familiar, you can finish it, but finish the case.
Diwala.
Grateful notes.
Would your lordship
at least direct early, would your lordship give a date? Because now that your lordships are not releasing it from there.
List in the week commencing 13th of May 2025.
Malat?
13th of May 2025.
It's the last week, man. It's a miscellaneous week. No, it's a miscellaneous week. Would your lordship put it the previous week at least? That's not a miscellaneous week.
On the 13th of May, date will be given for.
No, that's a. Please have it on 6th, my lord, previous week.
That court will have to, each court will have to have their own.
And Malaji, my learned friend is holding his hands with the word given to the court. He will be honoring. Malaji, we undertake that.
Sorry?
My learned friend's words will be honoring the status quo we maintained on this thing. Till the next date is only requesting all that.
I've already said what I did.
That's what all
I said. If your lordship recollect, day one, your lordship said, in the meantime, don't precipitate. I said I will not precipitate.
I'm grateful. That's all I wanted. I'm grateful.
You mean you want me to reiterate my words?
No. I want a confirmation for my own self.
Anyway, please, Mr.
Grateful. Lordship.
This matter, that a very important question of law is raised by SEBI.
That reappears.
Yes.
But this matter is different.
Milord, can I? Milord, there is something, Milord, I am not on merits.
Before the other bench.
Milord, I am for the COC. Milord, there's a very relevant point. This was against the interim order of admission. In the meantime, the final plan approval order was passed. They filed the appeal and withdrew it on delay. Nothing remains in this matter. It was against the interim order of admission.
It's a question of law.
Milord, it's become infructuous because the final order has been passed in the plan approval matter. And they filed the appeal against it.
I'm not on that.
So, Milord, nothing remains in this matter.
Mr.
1 minute is chair. You're not there.
Considering the important question which is involved, my lord, and we are for SEBI, we deal with such collective investment schemes. This honorable court was pleased to appoint Mr. Shyam Diwan as an amicus. It's a question of law. The plan may have been approved. The appeal is pending. So matter is not, my lord, has become infructuous. It will have to be heard.
We listen to Justice Patiwala.
Yes, sir.
Only
Lord,
one.
can I make just one request? If my Lord could just note my submission for the COC.
We are not,
that
we are not saying anything. You may please raise that submission before the bench concerned.
My Lord, it may be considered because your Lordships are listing it there. It's my duty. It's just my duty to point that out.
But that's fine. To point it out before that court.
Please, sir.
We listed before a bench presided over by Honorable Mr. Justice Patiwala in the week commencing say 13th of May 2024.
Please, sir.
Along with the appeal, other appeals mentioned in the order dated.
But they are actually not connected, my lords.
We are just simply recording. They will come up.
Not
the same day. In fact, but item 26.
Appeals number so and so, as mentioned. Appeals number so and so, as mentioned in the order dated 4/2/2025, will be also listed before the
Item 26 today is also on the same subject matter. I am appearing for SEBI in item 26 listed.
Item 26 also listed.
Yes.
Item 26 to be listed. Yes, to be listed before the bench or presided over by Honorable Mr. Justice Patiwala in the week commencing 13th of May 2025, along with other matter, along with the subject matter.
Can I be a little early if possible? Very best. Please, sir. Grateful to my lords.
Please, sir.
Lordship, High Court. Lordship, High Court though has acknowledged the arbitrability of the issue, Lordship. It has dismissed my Section 11.
What happened in Section 8?
It is pending, Your Lordship. Last 4 occasions, 6 months, Your Lordship.
Lord, 26 July 24, Lord.
Please do not speak like this. We'll ask you when your turn comes. What has happened in Section 8?
We have filed a Section 8 application. It's been more than 6 months. Nothing, they have not taken.
That's not been disposed of.
No, Your
Yes,
Lordship.
what do you say,
They are just taking adjournment every week.
What is Section 11 is, this order is wrong. It cannot be sustained. Yes. Section 11, you don't go into all those issues.
Yes, Lord. Lord, just Lordship, just look, Lord.
How can you go into all these issues in Section 11? That's what the arbitrator will decide.
26 July 24, Lord and Lordship, Lord, and made a query, Lord, to my learned friend that there was filed any application under Section 8, Lord. Lord, on that day there was no application filed. Lord, the application under Section 8 was Lord filed only on Lord 13th September 2024. And that is what Lord and Lordship Lord wanted them Lord to disclose. So Lord, Section 8 application was not filed at all.
May not be filed, but 1 minute please. Was it filed within the time stipulated in Section 8?
No, Lord. It is only Lord after the Lord.
What is the time stipulated in Section 8?
Lord, before the first statement of submission.
So when was the state? When did they file the
18th of February 2022? My Lord, written statement was filed by them. My Lord, after that, Lord, on 13th September 24, they filed this application, my Lord.
Then it's filed. File the written statement in that suit.
Yes, Your Lordship. I have filed it.
Then Section 8 will be dismissed.
And the suit was filed subsequently when the application was pending before the High Court, Your Lordship.
When was Section 11 filed?
First Section 11 application was filed in 2019. First invocation is 2017, Your Lordship. Then the matter was listed.
When was the application under Section 11 filed?
First application, Your Lordship.
When was the Section 11?
First invocation was 30th January 2017, Your Lordship.
30th?
January
That's invocation under 21.
Is invocation notice, Your Lordship. Then, Your Lordship, we filed the application in 2019, wherein the learned judge, he asked us to again invoke a fresh notice to be issued, and then you filed afresh. That's what we did it. Again, we invoke another notice, that is 3rd of October 2019, Your Lordship. Lordship, and they have filed this suit only in 2020 when the matter was pending. And we stated so in
when did you file the present application under Section 11?
Section 11, Your Lordship, 2020. The fresh application was filed in 2020. Just a moment, Your Lordship. This is 2020, Your Lordship.
January 2020. When was the suit filed?
2020.
When was the suit filed?
suit was filed, Your Lordship, in the month of
January.
February 2020, Your Lordship, wherein they have said so.
Just give me section, the arbitration resolution.
In fact, they have filed a reply subsequently after filing of the suit, Your Lordship, and they have said so in their reply to the arbitration application.
Did you, in your written statement, take the plea that there is
Yes,
an arbitration clause?
I have taken it.
Which is, where is that?
Your Lordship, it is at page 251. My written statement starts at 249, Your Lordship. Annexure P26, it starts at 249. The first, my objection is at 251, Your Lordship, para 3. 7th line from top, Your Lordship. Leave-in license agreement dated so-and-so filed by the respondents is barred by law of limitation and the same is not maintainable in view of clause 10K of the registered agreement of leave-in license 28 March 2013 between the applicant and the respondent herein. I crave leave to refer to and rely upon the same when produced at the hearing of the above application in this court. I say that the applicants have filed their written statements to the alleged suit and crave leave to refer and rely upon the same when it produced before the application.
Wait, you say you have already filed a
Mr. Lordship, I have filed a section 8 application.
No, where did you say about section 11?
I beg your pardon, Your Lordship.
Where did you say that you have already filed a petition under section 11?
I have said so, Your Lordship.
253 you have said.
Yes, Your Lordship.
Okay, now come to section 8. Learned counsel for the respondent, come to section 8 of the arbitration.
Lordship, Lord.
Come to subsection 3.
Lord, a judicial authority, Lord, before which, Lord, an action is brought in a matter which is the subject.
I am referring to subsection 3 to section 8.
Section 8, Lord. Subsection 3, Lord. Notwithstanding that an application has been made under subsection 1 and that the issue is pending before the judicial authority, an arbitration may be commenced or continued.
Now, in this case, he had filed the arbitration petition before, and in the paragraph 3 of the written statement, he has taken that plea. So let the matter go to arbitration.
Lord, what I submit to Lordship, Lord, since they have filed section 8 application, not before.
1 minute, not relevant now. Once in the written statement, they have taken that plea, and the section 11 was filed earlier.
But Lord, kindly see, my suit is, Lord, not for the only for the Lord.
That will be decided there in that suit. But as far as section 11 is concerned, that has to be allowed.
But my Lord, just Lordship will just have a look at Lord prayers in my plaint, my Lord, for a moment.
We are not concerned with the suit. We are just simply allowing section 11. That's it. That's right. It has to be allowed.
But my Lord, only one more request to Lordship, my Lord, to show an indulgence. My Lord, the earlier order of a Lordship, my Lord, Justice, my Lord, of the Honorable High Court, page, my Lord, 107, Lordship will have, page 120, my Lord, will have a look, my Lord.
Right, 120.
120, my Lord.
Yes.
I have not concealed, Your Lordship.
Page 120, my Lord, they earlier withdrew the, my Lord, section 11 application, my Lord, saying that they would be, my Lord, filing an application before the, my Lord, small causes court.
So then,
page 122, my Lord, I'm sorry.
So then, what does it show?
My Lord, the my Lord, petitioner, my Lord, sought, my Lord, leave from the, my Lord, High Court to file, my Lord, an application for arrears of rent. My Lord, in the small causes court, my Lord, they do not they, my Lord, file section 11 application for the recovery.
That will make a difference.
Arrears of rent.
That will make a difference. Nothing going. This is a very straight order, in fact, going into the merits of section 11 of the parties.
In fact, they had settled, my Lord, page 107.
Plea of settlement, accord and settlement has to be decided by the arbitrator, not by the court.
But they had no claim against us, my Lord, on 7.
What are you arguing, please, without reading the law of arbitration? Accord and satisfaction has to be examined by the arbitrator, not by the court. Right on. Be granted. The appellant, Allied Digital Services Limited, after issuing notice dated 16/10/2017, followed by another notice dated 3/10/2019 under section 21, of the Arbitration and Conciliation Act had filed arbitration application number 110 of 2010 before the High Court of Adjudicator at Bombay, which has been dismissed by the impugned judgment, which application has been dismissed by the impugned judgment dated 28th of August 2023. Stop. We would record that the fresh notice dated 3/10/2019 was issued by the appellant after an order dated by which the first fresh application was disposed of.
3rd June 2019, Your Lordship.
By order dated 3rd June 2019. Which page is that order?
Page 122, Your Lordship. Annexure P20.
The earlier arbitration application number 708 of 2019, 18. Was disposed of as withdrawn with liberty to issue fresh and appropriate invocation notice in continuation of the invocation notice dated 30th January 2017. Explain. The impugned the counsel for the respondent, Excel Dynamics India Private Limited, has relied upon the findings recorded in the impugned judgment and states this is a matter of accord and satisfaction, and hence the High Court was, and hence the appeal should not be accepted. Stop. Next page. In our opinion, the question of accord and satisfaction in the facts of the present case is required to be decided by the arbitrator and not by the court while dealing with an application under Section 11 of the Arbitration and of the ANC Act. When did you leave the premises?
Lord, in 2016 January, my Lord.
No, Lordship, this is in March.
Lord, we were dispossessed, so my Lord, we filed a police complaint.
Okay, fine. The dispute relates in this question, in the antecedent party relates to the event license agreement which was executed by the appellant in favor of the respondent. How much is the amount?
Lord, they were
more than 1 crore.
94,000. Lord, they settled at 9,94,000. Now they demand 1 crore.
Lordship,
It's about
damages
1.5 crores.
They say damages I am liable to
Lordship,
pay to them a lot.
the damages has been caused to the property, entire property.
Okay.
So we are seeking damages more than 1 CR, Your Lordship.
Okay, fine. Anybody from Bombay, senior advocate, who can handle be an arbitrator in the matter? Arbitration is to be held in Bombay?
Yes.
Yes, Your Lordship.
See. Anybody from Bombay, senior advocate, who can handle the matter? Very surprising, there's no.
Lord, let there be appointment from the panel of.
Why don't you, will you be able to handle the matter? Okay, fine. Anybody from next 2 seats, the senior advocates, will you be? Okay, fine. No, don't. Okay, fine. But now the senior advocate who is present in court is appointed as an arbitrator to adjudicate and decide the disputes intercede the party. You'll have the venue in Delhi then.
If it's possible.
Where is the arbitration clause?
Your Lordship, page 43, para K.
Page?
Page 43, para K. Should be in Bombay, Lordship.
Court shall be the court of Bombay. Not that the arbitration will be.
Yes, Lordship. We can appear through VC also. There is no problem.
Okay, fine. The President Court is appointed as an arbitrator. Stop. We shall file declaration in terms of section 12 with regard to the provisions of the ANC Act within 15 days. Stop. The venue of the arbitration will be fixed by the relevant arbitrator with the consent of the parties. Stop. Proceedings can also be held through video conference. Stop. The fourth schedule of the Arbitration Reconciliation Act will apply.
In your section 21 notice, your claim is for 4 crores 41 lakhs. Now you're saying it's only 1 crore.
Lordship, the second notice is.
So remember, your arbitrator's fee will keep on going up as you keep on increasing your claim. It's not like zero.
I
so be careful of that.
Yes.
The impute judgment is set aside and the appeal is allowed in aforesaid terms. We clarify we not expressed any opinions or merits of the case.
I'm grateful.
Lord, one request. Lord, the suit which we have filed with the contention that I have taken, my Lord, I may be permitted to take in the arbitration proceedings.
You want us to record? We can record. We can record that the application, that the suit is withdrawn by you and you can be entitled to raise all the pleas of contention. Make a statement carefully.
My Lord.
Don't
file. Lord, then only one thing, Lord, I may be.
Make a I'll be very happy if you.
Lord, not suit, Lord, then Lordship, we just observe, Lord, that all the contentions on merits are kept open, my Lord.
I have
No problem. Let him file a counterclaim.
No, you want to withdraw that suit, I can record.
Lord, I don't have instructions right now, my Lord, without the.
Then why you make that statement?
No, my Lord, only request, my Lord, that my contentions, my Lord, may be kept open, my Lord, even in the arbitration proceedings.
Just one more sentence you have. We may record that the respondent had filed a suit in February 2020, which is after the filing of the present, after filing of the arbitration, after filing of the petition under section 11 of the ANC Act, in which the impute judgment has been filed. Stop. The appellant has filed an application under section 8 of the ANC Act, which is stated to be pending. Stop. The appellant had also in the written statement referred to the pendency of the application under section 11 of the ANC Act and referred to the arbitration clause. Stop. We have passed the order appointing an arbitrator in terms of taking into account subsection 3 to section 8 of the ANC Act.
I'm grateful.
Item 17.
May Krishna. Lords, I am appearing for the petitioner, Lords. And this is regarding the governor and his jurisdiction under Article 200.
Mr. Venugopal.
Yes, my Lord.
I'll not be I don't want to reserve any more judgment.
By a sheer coincidence, Justice Milord Patiwala has delivered judgment this morning and rendered findings, my Lord, in every single aspect. Your Lordship may kindly direct it to be heard by Justice Patiwala next week also, because it's fully covered.
No, that I need to study that. I certainly will say it's not fully covered.
Very well, let him go and argue.
And an important matter, which your Lordship will not. And I advise the Home Ministry to file an affidavit because the governor is not filing an affidavit. And governor cannot be compelled to file an affidavit.
He had opportunities.
He's been advised to file an affidavit. We'll study the judgment, keep it up.
Opportunities over the last 2 years to file the counter.
Okay.
We put him and asked him to file the counter.
To be listed before a bench.
There is another matter pending before court number 8 today, which is State of Kerala, item number 43.
That also has to be
referred. Is presided over
Can
by,
be tagged with that.
No. Court number 8 is presided over by
But that also has to go before Justice Patiwala because the identical issues, all covered.
Just one minute. To be listed on administrative, no. Relist on in the relist in the week commencing 13th of May 2025. Let the next
13th May.
matter. Let it be part.
Very well.
Before Justice Padiwala.
No, Mr. Venugopal, I'm not saying anything. I'm just relisting it on 30. The week
You're ready to argue the matter, my lords.
I understand. I
Yes.
don't know. I don't know.
One submission.
Correct. You may be right in that, Mr. Venugopal.
No, I'll tell you, Lordship, why. For 23 months, the 7 bills were kept pending by the governor.
Let's see if the judgment is there. Let the judgment be examined. Let it be examined. If that is so, if it's covered by the judgment, it will be covered by the judgment.
Very well, much. But then the problem is this. It is very unfortunate because now for 2-3 years, my lords, bills have been kept pending. Can we imagine?
Mr. Venugopal, obviously the judgment has been pronounced today morning, so everybody will know about the contents and the directions given in the judgment.
Ideal thing is if it goes before Justice Padiwala's bench, it's already covered.
Next case, please.
Because for 3 years, no bills have been there.
Mr. Venugopal, I've given a very short date. We'll pass an order.
Surprise for us.
Lord, on 11th of October 23, Lord, my petition is listed before NCLT on Lord hearing. Lord, that day, Lord, my petition is dismissed. Lord, only partially it has been expressed that the petition would be dismissed. Lord, there is no judgment uploaded until Lord 3rd of November 2023.
3rd of
November 2023.
No, when it was announced in the court,
it was not pronounced, Lord, it was heard on 11th of October 23.
11th of October
23. Lord, as per the cause list also, Lord, it was listed for arguments and it was in fact heard on that day. Lord, thereafter, Lord,
order was reserved.
No, Lord, it was not. Lord, some expression was expressed by the learned judge saying that it will not be entertained, it will be dismissed, it will not be admitted. Lord, thereafter, it has not been signed on that date. It was only expressed in the court that it will be dismissed. Lord, thereafter, judgment is uploaded on 3rd of November 2023. And Lord, I filed the appeal before NCLAT on 5th of December 23. Lord, it's only a delay of 1 day. Not 1 or 2 days.
No, if we take the date from 11th of October.
Please, Lord, then there is a delay. Lord, there is a delay beyond.
We have to take the date. Look.
Please, Lord.
Normally, it's not the date when it is uploaded.
Please, Lord.
Which is taken into concern. I think Justice Oak has just pronounced a judgment on that.
Yes. Lord,
What is this? You can't argue that I'm not aware. Then what are you doing?
Lord, in fact, Lord, in terms of the judgment of Sanjay Pandurang, Lord, it says where the judgment is not pronounced on a day or it's not a day.
No. The judgment was pronounced or not pronounced?
Lord, it was not pronounced on that day. Lord,
1 minute, please. What is pronouncement of judgment?
Lord, pronouncement would be it is reserved for judgment on a
1 minute, please. You're wrong. We dictate open orders also in the court. Today I've dictated number of open orders in the court.
Please, Lord.
I'm not reserving any judgment.
Please, Lord.
So is it not pronounced then?
Lord, it is, Lord, it was not signed. Lord, we don't even know. Lord, it may be altered. There may be some other change. It may be kept for clarification. Lord, it may be, Lord, because this is the first court of, Lord, it's a trial court of sorts.
What is the finding of the trial court? Let's see the finding.
Lord, section 9 has been dismissed.
What what ground? There is a pre-existing dispute.
Lord, it's not holding that I had entered into some sort of settlement and therefore my amount was.
Let's see that. Let's see that.
Please, Lord. Lord, may I have page 18?
It's a pre-existing dispute.
Lord, 18 it starts.
When did you apply for certified copy?
Lord, 28th November.
28th November.
Lord, after it was uploaded on 3rd of November, I applied for 28th of November. And not immediately thereafter, I filed the appeal.
Which page is your order?
Lord, order starts at 18.
Page?
I'm so sorry. Ancient order.
367.
67.
Lord, 360. Lord, para 18 at 371, Lord.
It's not dictated in the open court.
Lord, this is not, it's a detailed order. Lord, I'm conceding to the fact that the expression has been given that my petition will be dismissed. Lord, unless not in terms of order 22, Lord, it has to be signed that day or not soon thereafter.
Please.
Please, Lord.
The date of the order is 11/10/2023.
Please, Lord.
Its typist name is also mentioned there at page 374.
Please, Lord. Lord, but Lord,
what is the finding given here?
If my Lord would have, my Lord, it starts at page, Lord, findings are at page 371. Lord, para 18 onwards.
Yes.
Lord, the factum of this amount is in ledger account is not disputed by the corporate debtor. Their own version of this amount is that it is an issue in dispute that is not resolved. Be that as it may, the learned counsel for the operational creditor pleaded that a full and final settlement proposal dated 3rd of March 23 was only an offer for a particular period of time which was not accepted, and therefore nothing turns on the offer of 40 lakhs as the final amount in debt. It was not acted upon and therefore it cannot be relied. In any event, prior to this proposed settlement, there is an admitted debt of rupees 1,77 lakh which remains unpaid, and therefore there is a case for admission of liability and unpaid debt. The contention of the learned counsel for the corporate debtor, on the other hand, is that the ledger account is a reflection of the bill submitted by the petitioner for an uncompleted work done in continuation of the work order dated August 18 as amended. The document which is relied by the petitioner to contend that there is an endorsement and acknowledgement, pages such and such, is countered by the respondent to state that it was received by the engineer in charge for verification of the claims petitioner, which is a consolidation of the bills submitted for the purpose of claim by the petitioner. It is not an admission of debt per se. The balance liability is in dispute due to incomplete work. In any event, the counsel for the corporate debtor vehemently pleads that the work was not completed in accordance with the work. That is why the petitioner respondent was in discussions. The final amount had to be determined only after the issue gets resolved. It is also pleaded by the counsel for the CD that the amount, approximately 40 lakhs, will be paid subject to the condition that the GST liability should be discharged by the operational creditor so that the benefit will accrue to the respondent corporate debtor. This is one of the bone contention between the parties. It is also stated that across the bar that even as on date, the CD is ready and willing to pay 40 lakhs without demur, subject to the proof of GST payments, and that is the crux of the issue in the case. Now, Lords may kindly have not paid, not para 22, not para 21. The learned counsel of the CD vehemently denies the stand taken by the counsel for the OC that in addition to 40 lakhs referred in the proposed settlement dated 3rd of March 23, it did not factor in any talk of giving of a property in lieu of the balance amount. This statement in the rejoinder is refuted by the learned counsel for the corporate debtor. We also find that the statement in the rejoinder that over and above 40 lakhs, the settlement would be also include a property to offset the total claim of 177 is not corroborated by any document signed by the corporate debtor. Therefore, we are not able to accept the stand taken by the petitioner in the rejoinder with regard to a plot land in lieu in excess of 40 lakhs should be taken into consideration. Lord, in fact, Lord, the settlement which has been entered into between the parties was never signed by Lord the CD. Lord, I signed it, sent it to them, confirmed on the email that we are ready to agree at a lesser amount.
But there's a dispute about the amount.
Lord,
and less than 1 crore is not maintainable.
Lord,
less than 1 crore is not maintainable.
Lord, they send me by emails the ledger statement, which they say that it's subject to finalize.
Statement, look, you're right. He must have claimed this as an expenditure in his income tax returns. There's no doubt about it. He's claimed it as an expenditure in his income tax returns. Because that's why in the ledger account, what he's done is he's put the bills. But he's now raising the dispute saying, I'm not going to make it payment because of the delay in the process. You pay him 40 lakhs.
If you will just have to
pay him 40 lakhs.
I'll take instructions on that. Actually, what this I was okay. It was heard on 3 dates, 9th, 10th, and 11th. Your Lordship will have my reply for a moment.
Look, this is a mess. The whole case is a mess. The way things are being done in court. In fact, because look, this is hope judgment is there in your favor. I'm not denying that. But the whole thing is a mess. It's mess is arising also on account of the fact that the rules say you have to give them a free copy. Correct? The orders which is dictated on 11/10 is not uploaded to 3/11. How does he know what is the order, whether there is an exchange or not?
In fact, he had his own printout. The order was uploaded on the third.
My friend will just.
There's a printout from the NCLT minutes.
That the order was uploaded on
3rd of November.
But we have an 28.
See this for a moment, Millets. It was listed on the 9th, then 10th, then 11th.
It was listed on
9th of October, then 10th of October.
No, but 11th it was reserved.
Yes, not it wasn't reserved. It was announced. My Lord, may see the order which was uploaded on the 3rd of November.
And Lord, if Lord would have page 411, Lord, in response to my email sent to the registry of NCLT, the registry has responded by an email, Lord, saying that it has been uploaded on 3rd of November 2023 at 5 a.m. Lord, I could not have known the contents of the order until.
No, that's not the point. You could have applied for a certified copy to save yourself.
Lord,
all that was required was applying for certified case. So that's on your on the part of the concerned lawyer, because he should have filed the application. If he had filed an application for certified copy, this problem wouldn't have arisen. It's their fault. The orders do get uploaded, not necessarily the same day, but after some time. But if it had been, it would have.
Had it been someday,
3 days thereafter. Day after the order.
That's sure. 11th. No, if he applies after the limitation period, then he doesn't get benefit of conservation.
That's the issue, but that's the ground on which the NCLT has dismissed it.
Lord, if not, may I just draw one parallel?
Law, sorry, we will not interfere. Even on merits, you don't have to interfere. You do not try to put ground and interfere with the human judgment against the appeal justice.
Lord, let him at least not pay by 40 lakhs. Lord, he had agreed.
File a civil suit. $18 or $19?
18
is over.
Yes, to do fresh IAs, if your lordships can issue notice. I'm the respondent in IA.
What is the application for?
They are home buyers, they want the registration.
Yes, Milord, I represent all of them.
Let me take instructions, if your lordships issues notice.
Okay, issue notice, IA number, sir. Issue notice returnable in the week commencing.
Lordship, may I submit? My lords may recall this notice was issued was section 14 explanation whether this could have been whether that delay aspect
that's on merit
be considered on.
IA is something else.
I didn't understand.
Lordship may just for a moment have order dated 19/7/24. This was first a civil appeal was filed, and thereafter, my lords, liberty was sought and an SLP was filed. Whether that SLP itself is maintainable and for the successful resolution application.
Oh, that has been written. Now, Justice Chandrachud has said.
Please, Lordship, I have placed that judgment in my counter affidavit as well, Lordship.
See what happens. once it's been held, 136 will not lie. This
No,
has to be
your lordships have been pleased to flag that issue.
No, I know, but it was done without being aware of the order passed by the.
This will have to be heard. And I
No, that has to be.
That is part of my counter affidavit, Lordship.
I'm not.
Lordship, in fact, the IAs are the home buyers and SRA, which is successful. We are on the same page. They're ad item.
No, I understand, Manoj, but we were only for
Where's the judgment?
Page 20 of my counter affidavit, Lordship.
Then it kindly have it on some day, Manoj. Let me be ready and address the court.
Page
20 of my counter affidavit, Lordships. Directly covers the issue, Lord.
By R2.
Please, Lordships.
That it comes for the second respondent. Relies upon order dated.
Not civil appeal is not delayed. That's what the.
Lordship, but I.
Would your lordship see?
No, I'm not deciding it. Don't worry. I'm not deciding it, but I'm just bringing it on record that you be prepared for arguments because this may be an important issue in several other matters.
That's one of the main issue, not in this.
But trying to say the view appears, we all both were discussing the appeal appears to be correct. It's not the issue. You see, we have over the period of time diluted the limitation periods. It's time we start enforcing them. And when we enforce against the government departments, the citizens also become.
They should be at par. There is no doubt.
No. First enforce it against government because government itself has that limitation. Once you do that, then everybody follows the line. Now, but before, there's hardly any before of the Arbitration Constitution Act again, there's hardly any lapse. But you look at other matters, 136 where we have fiction trial. Every appeal is delayed. Every matter is delayed. But if we start enforcing even in 136, immediate action would be.
Kindly distinction is this.
We are not dismissing it at this stage, but just
the distinction is here. The order which my learned friend relies upon, the civil appeal was delayed before your lordships, and therefore 136.
Aware of it, but
our case,
but they look, and it's a town and country planning department.
In fact, before the NCLT,
if they cannot handle their own affairs properly, then who else can?
Before your lordships, there is no delay. The delay was at NCLT stage. That's the distinction.
No, at the NCLT stage there was a delay.
Yes, not here. So this judgment, the reliance on this judgment is misplaced. This order is misplaced.
Lordship, here is a case that
this order will then not be applicable.
No, Lordship. In fact, what has happened is that delay has been consistent before the NCLT, before the NCLT.
Let's examine this.
Please, Lordship, as my lord.
That order will not be of any.
Lordship, in fact, my lords,
the reliance on this order is misplaced. That's what.
While issuing, also my lords had indicated that the issue of maintainability will also be heard at the time.
Correct. We have issue notice on both applications. Issue notice returnable in the week commencing.
You may give a date, Lordship, because despite having the plan being approved, it's not
13th of May 2025.
Obliged.
Full stop. List the appeal itself. The appeal will be also listed on the same in the same week.
Grateful.
Obliged.
Other cases after recess. notice is the key.
No, my lord, this is a matter of the drug for spinal.
Yes,
yes.
okay, find the solution.
Yes, so my lord, solution has been found. My friend should have told your lordship. My lord, another matter.
The opportunity.
No, because you were appearing in another case. What happened was, my lord, for all this, my lord, there was another matter in the Delhi High Court before Justice Pratibha Singh. She called all the manufacturers. She called the government. She said, you please negotiate and bring down the prices. So, my lord, we had negotiations with the government. Government accepted, and we have substantially reduced the prices by more than 50%, only for India. We then showed it to the learned judge. The learned judge was satisfied, my lord, with our agreement with the government, and the judge said that now you proceed. That, my lord, I want to show you that part is over.
We don't know what the price is. We know what is in China and Pakistan. We don't know here.
Scroll back, then I complete. Yeah. I am now going to show to the Chief Justice what was agreed, my lord, before. This is confidential. So, my lord, what was said in the Delhi High Court, I am showing to my lord. The lordship will find more than substantial, I would say.
The court saw it after calling all relevant parties
Because
into it.
we sell it across the world. We have different agreements, different confidentialities with sovereign governments. But just have a look at this. It will more than satisfy lordship's conscience. Your lordship will note. Kindly see page 2. Page 2. If your lordship will see, my lord, the first item, the 3 columns, excluding GST, including custom, including everything. Now, my lord, your lordship will be pleased to see column 3, proposed. So, my lord, broadly it is now X%.
Okay, fine. Now, but tell me, how long will this drug has to be taken? It's lifelong?
Lifetime. No. So what has happened is this, Lord. And as far as we are concerned, Lord, we give to Government of India. Government of India gives, Lord, to various patients. There are about 1,200 of them in India, at least were discovered. Now the government said that we will give to them only up to 50 lakhs per patient. What they said. Can't give it for, Lord, all life. It will become 25 crores per person. The government said we can't do that. Justice Pratibha Singh said, no, you go beyond that 50 lakhs. The government of India is an appeal against.
No, that we ought to be aware.
In that direction.
No, because you see, government of India has also got limited funds.
Yes, correct.
They have to.
So that's
given the population.
That's right.
Everybody will be required.
So the government of India has an appeal on that issue, Lord, in this Justice Pratibha Singh's appeal. But as far as we are concerned, we have not challenged this decision, and we have reached this settlement. This settlement was shown, Miller, to the judge. Give copies, please. Give copies. Open out that paragraph. Give to both them. Kindly. Miller, the Lordship will find paragraph 332. I have opened that page for the Lordship. Paragraph 332.
No, but if you turn to page 2.
Yes.
Of your
yes,
the confidential document.
Yes.
You are given last 2 columns are what? These are lifetime. These are annual cost.
No. This is, Lord, a cost of 1 bottle.
1 year.
Last 2.
The
shaded
annual cost.
Annual.
Average annual cost.
Cost for type 1.
Yeah, correct.
So these
because 1 bottle, my lord, lasts you for about 3 to 4 weeks. So you need to have, my lord, for you have 12 to 15 bottles or 20 bottles.
3 bottles a month.
So if you have
3 bottles, because she's over 20, 36 bottles, which cost.
Depends on the, one second, please. It depends on the age of the child. The child is younger, Lord, you require less. Child is more.
It's the weight, not the age.
Or by weight. So that depends on age, Lord. A younger child is, Lord, less weight. So that's how it goes. And the government said that we will give you free till 50 lakhs. That's where it stands, Lord. As far as I am concerned, the third shaded is the one I have brought down to from the first sheet. Now, my lord, Can I just copy? I have seen that paragraph. My Lord the Chief Justice Sanjay Kumar. Para 332. Spinal muscular atrophy. Insofar as SMA, the atrophy is concerned, negotiations have taken place between NRDC, that's belong to the specially appointed body of the Government of India, and Messrs. Roche, that is me, which has given a price has now been accepted by NRDC as captured in the document signed by so and so. This document belongs only to the Government of India, it's not with me. The procurement approvals may now be. So this, and my learned friend was the counsel.
As it stands, the price in India is now substantially lower. I will not like to reveal the figure.
But my point was slightly different. Now, please see my affidavit.
Mr. Grover, we cannot direct what the government should do, what the government will not do.
But your lordships can. I'm sorry.
No, I'm sorry, we cannot. We will not.
Just see.
That means examine. That cannot be done as an interim measure, and it has its own consequences. Mr. Grover, for you, it's very simple. It has international repercussions. We require people. No, 1 minute, Mr. Grover.
Yes.
For you, it's very simple to say, okay, in all cases, now let the government fix the prices, but it has its own consequences in the sense that R&D, which has taken place abroad, we have to get the medicine over here. If the medicine is not being supplied, in every case we're going to say, okay, medicine.
I'm not on that, Lord.
We cannot do that.
No, I'm not on that. But your lordship may keep this issue alive.
We will keep it alive. We are not.
But then let me address.
It's a very delicate issue. It should not be read as saying one way or the other. No, obviously, we'll write the medicines to be given at the lowest price.
Two things, Lord. As
Can
I?
minute as a matter of good
How can you counsel me arguing
as a
for
matter
the same
of
party?
goodwill gesture for this person? We have also written to her to say that for 1 year we are giving you free. We don't need to do it.
Why did you do that then?
We have done it. We have written to the person. Right apart from the merits, this is without prejudice to what is being shown to my lords as a goodwill gesture.
So
even
the
if it's done that.
50 lakhs
It's given or to be given now?
They have offered us, my lord.
Already given.
Can you just allow me to speak?
Should you not have told us?
You are not here. Don't say things.
I'm talking about this. There's no who are a counsel.
Please come and say. Please come and say.
It happened on the weekend.
Okay, fine.
It should be. No,
I'm talking about the judgment. My claim to the counsel.
Mr. Grover. Mr. Grover.
No, he should not make statements like this. I'm a responsible counsel and he's a senior counsel. He should talk like that. I have told you not to.
Okay, Mr.
He is responsible.
No, what has happened?
What is saying?
Okay, what has happened over the weekend?
Over the weekend, in fact, I was going to say that before Mr. Call started. They have offered us. We are very grateful. No difficulty. We are on a larger issue, but the lordship has made a point clear. I wanted to only say two things, Lord.
Yeah, I have not made my mind clear. I've only expressed my.
This is not that. I appreciate that.
I can't.
I appreciate the lordship giving notice to them. Something has happened which is beneficial. I'm thankful to your lordship. My point was on this.
Neither have I expressed my mind on the question what we should do or what the government should do. Because these are questions and doubts which come through my mind.
I know something about this. I've been working on this for the last 20 minutes. Two things. Firstly, as far as this particular case is concerned, what I heard before the last time was that we have had negotiations. We don't know what the balance is. I don't agree that they should be kept in a confidential cover. It should be public knowledge. One, but I'm not insisting today. What I was on was that in China and Russia, I put it on an affidavit, it's never been denied. Each bottle, look at this. That time, we don't know what the price is now. A 20 kilogram bottle was $7,200 in India. Before in China, in China it's $545. $545, less than 10%. In Pakistan, the Pakistani negotiations with NGOs, China with government. My point was, why can't we bring it down to this? Why should we not? I'm not going to insist on it now, Milord. Leave that open because I don't want to. On the other issue, let me just say this. That's not the factor. I'm not going to argue it. Not Colombia. Saying international ramifications. I appreciate that. Colombia has issued, not in this case, a compulsory license order in a hepatitis B drug. That's what I mean. Why we afraid of international?
Maybe you are right.
We
are not saying that. look,
Spell your lordships.
no, I'm not, look, 1 minute.
Very well.
So when I said that, it was not with the intent that it should not be done or cannot be done.
That's why I'm not
But
going.
I was just pointing out, there's a counter viewpoint. There's a counter viewpoint, whether that viewpoint is acceptable or
No,
that's a matter of debate.
I appreciate that.
And then if required, a matter of judgment and a decision.
But the lordships has said in the other matter, when Mr. Vikasi was appearing. I don't know whether the lordships will decide that now.
Now we'll keep it pending.
Pending, very. Now, my lord, we are going to sign the document. And it was for 1 year, for which we are
Right up.
One
sealed envelope was produced before us. The sealed envelope with regard to it, which refers to the pricing settled with
Para 332. Para 330.
a sealed document relating to the pricing settled by pricing of SMA. Okay. No, this is spinal muscular
atrophy.
Spinal muscular atrophy.
Okay.
SMA.
Price of, let's see. Pricing of Everest.
Okay, right. Let's just strike that thing. A sealed envelope rating the price with regard to the price negotiated by NRDC stands for National
Rare Disease Committee.
National Rare Disease
Committee.
Rare Disease Committee and Roche Pharma with regard to the drug Everesty, EVRYSDI, as we within brackets Resipam, RISDIPHAM, has been produced before us in sealed cover and has been returned. Look, next paragraph. We are happy to note and record that Roche Pharma has agreed to supply the drug
For 1 year.
Drug in question to
SD plan.
the patient in question free of cost for a period of 1 year.
This is without prejudice.
Without prejudice.
This is
You also.
I have something else to say.
No, you've also been given a year's supply.
No, I'm for an association of all the parents.
This child is SEBA. For SEBA PA is the association.
Cure
They
SMA.
were told that the child is less than 2 years.
No, Cure SMA is me. That's an association of 1,500, the largest association. We have all the parents.
What do I say?
It's a patient.
It's a patient.
She's a patient
Free of cost for a period of 1 year. So stop. This it is submitted on behalf of Roche Pharma is without prejudice to the rights of contention. Full stop. Yes, Mr. Gopal Chandra.
I just want to point out that there are 6 different proceedings pending on this issue before this court. If your lordship would just put them
Different
together.
courts, before the different courts,
Different courtrooms.
different benches.
Yes, but different. One is before 3, one is before 5 as well. But if I just want the hand up because they have.
It is pointed out.
Only one request. What is pending in court 3 is an army matter. They have a completely different isolated dispensation. So even you can tag it, but it has to be heard separately. We can't put it in the general pool.
Now, army matter means what?
Lord, 1 minute. Can I? Lord, may I explain it? Lord, for army personnel, they have a completely different scheme with army. And that is independent of the government circular. So that scheme is separate and that is in court 3. Lordship, it's again rare diseases.
No, then let it not be clubbed.
Yes. And your lordship can tag it, but it has to be heard separately.
I'd rather not do that. It will get because that scheme must be having upper limit.
It's not as per the scheme, but I'm appearing there for the petitioner. I can tell you.
It's not as per government scheme, it's as per defense rules. So it's completely different, complete. Let's not, they are apples and oranges. I'll have to say that from the government's perspective, because I'm doing both the matters.
Okay, Mr. Balchandran, let it be before the bench.
No, the reason is, if your lordship sees this list, there are different diseases of this sort. Your lordships are dealing with muscular atrophy at this moment. Muscular dystrophy is before another bench. What I'm suggesting,
that can be grabbed because all of them,
yes,
which relate to that 50 lakh cap.
Yes, they are.
all of them,
All of them,
including the one my friend is referring.
1 minute,
is referring to.
As long as they relate to the 50 lakh cap,
Yeah.
can be before one bench.
Correct.
Yes.
But in case there is any issue,
Yes.
which is relating to the cap, which is applicable to ex-army men.
No, it's the same cap. It's the same cap of 50 lakhs. There's nothing
My
different.
friends can say anything. We have filed affidavits before this court. I say it in the sense of responsibility.
We may follow the same.
I have
Okay.
the army rules. They are completely different and distinct.
I didn't interrupt my friend.
No, you can't mistake.
This the present specially petition, along with writ petitions 1, specially petition 2. Which one is the army matter?
4, item 4. If your lordship want to leave that separately, please do. We'll
leave that separately.
Very well.
I'm going to record it.
Yes, please record it.
No, I'm going. I'm going to record both of your statements.
Yes,
statements by both of you.
We stand by it.
So what that can be decided a little later.
Very well. And 5.
And 5.
Yes.
During the course of hearings, there was some debate whether the writ petition C number 843 of 2024, Jashmi Mahina through her mother versus Union of India, is entirely whether the issue raised in so is entirely similar or not. So we at this moment not examining and going to the same question. The bench dealing with that, the bench hearing this writ petition number 843 of 2024 may decide appropriate.
One last request. I have an IA for impleadment. I appear for the parents. This association is the main association across the country. So if that impleadment can be allowed, it's IA 87715. I'm great.
One last statement, my lord. Lord, in case
This before the bench presided over by PS Nasimha.
And Lord, one last request to your lordships me. Lord, as the matter progresses, ultimately health is a state subject. So, Lord, we'll have to implead all the states because it can't be only that you decide it in union. Lord, we are doing it to the best of our ability and handholding it to the extent possible. No. It's not as simple. Lord,
you know what the state should say.
No, let it be so. Lord, it's a responsibility. Lord, one minute is a shared responsibility. There are 2 statements. Lord, we would like to make 2 statements to this court. One, it's a one writ.
Leave it for the other bench.
Yes, it's a state subject.
Leave it for
and Lord, these people are in touch with the state governments and they are having their own dispensation. So all this should come on record. At some point of time, it's just making a statement. Oblige your lordships.
List in the week commencing 13th of May 2025.
Oblige your lordships.
Grateful manners.
Item 46.
What has happened is this.
Mr. Let the High Court decide that matter. You can come up here if the decision is against it.
One way. The other way is that when we filed the petition,
normally. No, what the question? Just 1 minute. As far as search and seizure is concerned, I think 1959 is the first judgment because I was an income tax counsel, so and Puranmal settles that issue.
Lord is now different.
It's not even their pleading in the High Court.
1 minute, please, Mr. Tushar Mehta.
It is not.
Mr. Tushar Mehta, if you want, I can't.
That's all. All I'm saying is,
No, let it not be. Let it be decided. We are here. We are not going away.
I'm saying, my lord, it's already.
No, let it be. Let that be decided there. You can come up. No, don't do that. I've gone through the other matters. The other matters which pertain to primarily the guidelines was for seizure of electronic devices is pertaining to the journalists because there the privacy issue is a little higher.
Question raised here.
Can you, by force or coercion, take out without the entire material in the phone under the guise of investigation? What happens to Puttu Swami? What happens to Article 21?
That's the larger question which is already pending. It's more important in the case of.
So finally, EDS
Which is pending.
which is also pending,
There's
saying
no
that we have a right. Puttu Swami must have an exception which is there.
Okay, let the Madras High Court deal. Right now.
I'm willing to withdraw.
Okay, you withdraw this. No, don't withdraw your petition from there. I thought you want to withdraw the transfer petition.
So this also I'll withdraw them.
No, we are not saying anything on that. You want to withdraw this, you can withdraw this.
This I withdraw.
But I'm not going to say what you're going to do there. Senior advocate.
But as a matter, I must tell you, Lordship,
it's his wish. Let him do what he
wants. Only one thing, Lord, we must tell your Lordship, truly, whatever.
Mr. Tushar, you sometimes also argue, please call all the matters over here. Don't do that.
I am not saying that. But
no, but in some cases, do you ask?
First of all, that this issue is not even pleaded here. And the last order, both sides agree that we will proceed with the matter on this particular day. That should have been pointed out in all.
I'll withdraw it there.
Mr. Okay, you decide. We are not.
Forum shopping, that's what we are saying.
Sure. Yes.
If I withdraw and come here, it's a.
The senior advocate appearing for the petitioner seeks permission to withdraw the transfer petition. In view of the statement made, transfer petition is dismissed.
My learned friend is right, my lord. I can demonstrate it's foreign shopping. But
Pardon?
it is foreign shopping in a different way, in a peculiar way.
Yes, Your Lordships. Your Lordships, in this matter, I'll be needing at least a week's time for filing my counter. It's ready. It's only to be finalized.
It's only a legal issue. My lords have framed the issues by my lords order dated 30th September 24.
So we need to address on those points because there are two consecutive orders which are in my favor.
Well, transfer claim for the respondent, raised for is granted 4 weeks time to file the reply. Stroke counter affidavit. Rejoinder if any within 4 weeks after service of the reply stroke counter affidavit. Read list in the week commencing 11th of August 2025.
Much obliged, Your Lordships.
Great.
Or should we grant leave in this case?
As Your Lordships.
Matter will require consideration.
My lords can grant leave in the matter.
This order, Your Lordships,
Because
there is a state which I am already suffering in this.
So leave granted and then you say.
Great.
Before my lords adjudicate on this matter, Your Lordship, with consent from my learned friend, if this matter can be referred for mediation here, Your Lordship, we will try to settle the matter because it is for the appointment of an arbitrator. So I have a talk with my client also. They are ready for mediation, Your Lordship, if it can be worked out here. Your Lordship,
That's because parties jointly swift the matter, then we refer to Supreme Court mediation center, explore possible using. In view of the statement followed to take. It's okay. So parties to appear before the mediator nominated by the Supreme Court Mediation Center on 29th of April 2025. This before the court in the week commencing 28th of July 2025.
I'm ready.
Please, Your Lordships. My lords, my IA number 60724 sets out the very unfortunate developments after Your Lordship's order. Please see IA 607, the relevant documents are there. That's why I'll take just a minute. My lords, in that IA 60724, Mr. Courtmaster, have you given their lordships? Yes.
So first, let me apprise your
No,
lordships.
just 1 minute. Allow me to finish, my lord. I'm for the petitioner. Unfortunately, the Siliguri Municipal Development Authority has gone completely against your lordship's order, rendering the entire tender process useless. I'll just show your lordships. Please see my IA 60724. Your lordship's order is at page 36. Please turn to page 36. I gave you. It's been served, but I'll give you another copy, please. This service proof. Anyway,
File number 10724 is separate.
Hold on.
My lord, kindly.
Yes.
My lord, Justice Sanjay Kumar got that, my lord, same order.
Yes.
Please turn to page 34 is your lordship's order. Kindly see page 36.
Yes.
Your lordship say these will be the terms and conditions starting at page 35, A onwards. E, the lease period shall be for a period of 99 years. Lease rent of 1 rupee shall be payable for the entire tenure of the lease. Draft of the lease deed shall be uploaded by the SGDA on their website on so-and-so date. That was the condition on which it was to be given. Now let me say 2 things which happen after that. First of all, they come out, my lords, with the terms and conditions of the lease. First thing which happens is a party writes to us after your lordship's order and says, I have a charge on the property. That property part of it, there's also a High Court order which has said that nothing, any purchaser of it is subject to the earlier charge. Page 41, my lords. Kindly see the lease itself, the sample of the lease which has been given, of the additional documents filed with this. Starts at, my lords, page 1 at page 12. 1 minute, please. Has my lord got the additional? 3 things have happened. I want to show your lordships 3 things they do. This was a lease for 99 years where you virtually bought the property. Your lordships also gave permission to mortgage the property to the virtual sale, but 99 years. Now they add, I just want to show your lordships, page 13. These are the terms and conditions. This lessee shall, clause 4, lessee shall utilize the plot for the purpose for which it is leased within 3 years from the date of issue of order sanctioning such lease, failing which lessor reserves the right to resume the plot after giving lessee an opportunity to be heard. Then 7A, lessee shall not transfer or assign his leasehold interest on the demised premise, whether in full or part, without the formal permission of the lessor. Then it goes on further. Kindly see page 15, which is shocking. 15A. Page 15, 15A clause. If the demised land or any part thereof shall at any time be required by the government for a public purpose, the lessee shall give up the same on demand without any claim to compensation in respect of the...
What is this 15A clause?
I'm not aware.
Well, I will show your lordship. This is their terms. This is their lease terms.
But this 15A
their document.
Sorry.
This 15A clause is ridiculous. I can understand the other clauses.
No, there is one other clause which is that they're charging us an annual
say that I can take away the land. Yeah. What is this forfeiture?
No, the lordship.
This is absurd.
One other clause. Your lordship said
it makes no sense. Who's going to give a bid? You don't want any bid?
That's why we did not bid and we want to withdraw our money and go. We don't want this. And one step worse. Your lordship said lease rent shall be 1 rupee. That's your lordship's order. They put in this.
Okay, you pay the money. Let the state government pay the money.
They put in this.
They pay the money. Then we ask the state government to pay the money if they want to impose.
I withdraw, my lords. Let the money be paid back to us. 50 crores we had to
pay the money to the degree holder.
Your lordship,
then we'll attach your assets. Let the money be paid.
Lordship, I'm not aware, but I may say this, Lord. I may accept.
So tell me, will you ever purchase a property which says that the clause says?
Delete those conditions.
Well, why did you impose it first?
No, I'm not aware.
Somebody must have read it. Somebody must have done it.
That's right.
Somebody must have applied his mind.
Consulted me before issue.
No, we are not concerned whether it consulted you, A, B, or C. But somebody should have applied his mind. Absolutely. Will anybody give a bid with these conditions? Will you ever buy a property where it says that the owner, the superior lessor, can always take away the property without paying a penny to you?
I agree.
Well, the tip of the iceberg. There's another clause that they can terminate at any time. I haven't yet come there. They can terminate at any time as another clause.
I can understand you saying, okay, 1 rupee we are only concerned with the money to be paid to them. We feel that if the lease rent is also fixed, we will still be able to get the amount of money which is paid to the degree holder. Fine, there's no difficulty in modifying that. But you can't put conditions which ensure that nobody gives a bid. Otherwise, we'll say the state government will pay the money. We got no difficulty.
Well, the last point I must point out, they know there is an order of the High Court against them in that other litigation saying that any transfer that is going to be made will be subject, and it should clearly state that there is. They come out to the lease without disclosing it. There is no disclosure. And then they say bought in an as is, where is condition.
No, it cannot be as is, where is condition.
And
you must tell us what you have to tell us. Can the state say as is, where is condition? I can understand you're selling a motor car or something where you don't, somebody may come up with the saying that second-hand car which has this thing is faulty, that thing is faulty. Can't do this. State cannot come up with it.
May I point out one thing? I'm for the degree.
This is an intervention, but not first. It has to be heard whether intervention or is to be heard or not. They are coming on a fresh application now, my lord.
It's honorable. We'll issue fresh advertisement, my lord, and we'll delete all these conditions.
What is this, please?
I'm so sorry, my lord.
This is like saying that I'm the state and therefore I can do what I want to do. Other person may.
That can't be.
Can anybody do that?
That can't be supported.
My lords, one more clause they've added. This particular person who has a degree.
If we had imposed certain harsh conditions, you require them to be diluted, move an application, we change it. We are not still stone or thinking that. What's there in this? We can always change our the terms if they were reasonable.
My lord, there is one more problem for us. 62 acres out of the 92 acres, 16 acres out of the 92 acres, there is this decree holder who, my lords, in the High Court has got an order that this is subject and any sale can is subject to the outcome, and any sale has to state specifically subject to the outcome. Who will buy this order?
Yes, my lord. That is what I would.
Please. That interim order will not give you a charge.
Yes. My lord,
no interim order, even attachment before judgment doesn't give you a charge. That's a correct position in law.
The issue.
1 minute, please. Until unless it's a mortgage, it doesn't give you a charge. Very clear. What can be done is, instead of putting an obstacle, let the property be sold, because here there is a degree already there. Your case, is there a degree or it's a attachment before judgment?
My lord, I'm the owner of 16 acres. I have filed writ petitions challenging the acquisition order. After that, my lord,
I cannot challenge. Look, at best you'll be entitled to the
compensation.
Compensation.
Please, my lord.
That you can't go beyond that.
So, my lord, we don't want to come in the way of the auction. What we are saying that the Honorable High Court's order should also be revealed to the Honorable Supreme
That will be done. You cannot have a charge on the property.
Not to say a charge.
I'm sorry to point out one thing, Lord. In fact, their whole
was dealt by the single bench. Can I just complete my submission? I want to withdraw my 50 crores.
They are not deposited. They can't withdraw.
I want to withdraw it.
With these type of things, what can be done?
I'm saying, Lord, two things, Lord.
Why should
in fact, when the bid was fixed, Lord, they did not even go and attend the bid also. And Lord, there was a time.
Obviously, I did not attend the bid. I did
not. Did any bidders come or?
No, nobody came forward. And Lord, they also never informed.
How will anybody come forward? Okay, you pay the money now. State government will have to pay the money for what the losses cost. For the entire bid amount, you pay the money. That will be a good lesson.
Just give a charge.
No. Please pay the money. Pay the money for the expenses incurred. That will be good. That's fine. You pay the money for how much was it?
About 200 crore rupees, Lord. I'll file the calculation.
No. I've not done that. The expenses incurred for the advertisement.
As far as I'm concerned, I want my money back.
This time they paid. Last time I had paid, Lord. On the last, because this is the second advertisement, Lord. First time, Lord, before.
How much is the total expense?
I give Lord something around about 5 lakh rupees. There was an officer of
the court
appointed as.
We'll pay that 10 lakh. Lord, give us a chance, my lord, again.
And Lord, two things, my lord. On the chance.
10 lakhs. Otherwise, we settle the liability or you pay the money. You take the land, pay the money. Why not? You want to impose conditions. You impose those conditions, but pay off.
We'll pay.
You can't.
My lords, would your lordships?
That's a fault on our part. So
would your lordships allow my IA 60724 because my IA is for a prayer that my money be withdrawn and I be allowed to.
Every month, 62 lakh rupees, my lord, the state is incurring a loss.
IA 60724.
Look, with this type of scenario, who could give bid?
There was already a bidder, my lord, before the High Court, my lord, somebody had put in a bid, 40 crores deposited, 400 was freezed. And my lord, one more thing, my lord. First time, my lord, when the appeasement took place, my lord, before the single bench executing court, they did the entire same thing, my lord. I can show the.
Okay, fine.
That time also.
Give me the application.
My lords, my IA.
There is already a bidder, my lord.
It will have to be given a fresh bid, will have to be taken up. We can't help it now. The state government will be asked to deposit 10 lakh of rupees for the next bid, for the expenses to be incurred for the next bid.
But one confirmed bidder is already there.
Nobody gave the bid this time.
In the last round, 440 they have deposited.
1 minute, please. After that, a lot of water has flown. Let's have another bid. We'll allow him to withdraw, number one. Number two, the state government will deposit 10 lakhs, which will get used for the next bid.
My lords, my prayers are at page 14 of my IA.
Just the auction. Yeah. You paid your money?
Is not claimed.
You have been paid your money or not claimed? No, but just check it up. It shouldn't happen that you have not been paid.
My lords, I have received the bill, my lords. I have forwarded it to the department.
They will pay.
Karima ma'am's bill. I have received.
Please pay that.
My lords, I'll do.
My IA is, sorry.
Obviously.
My lord, my IA is 60724. Kindly allow it, my lords, page 14.
I'm sure only the state government can give a bid.
Now, on these conditions, my lords, in fact, they are saying now rent will have to be paid at market value. Then what is the 400 crores for?
You're walking out now.
No, I'm walking out anyway. My lord, page 14. My prayers are at page 14.
Right on. IA number 60724.
Prayers are at page 14, man.
Attention is drawn to the release date drawn out. Submit that there's variation between the lease clauses and the terms which were fixed by the court by an order dated 16/12/2024. Full stop. It is pointed out that the terms of the lease as propounded makes it impossible for any bidder to give a suitable bid, as there are stipulations with regard to payment of market rent, cancellation of the Siliguri Jayapalguri Development Authority to deposit rupees 10 lakhs in the spot within a period of 3 weeks from today towards expenses incurred and as cost for having proposed a lease date which was a complete variance with the decisions given by the court. So stop. Siliguri Jayapalguri Development Authority will also ensure that payment to MS Karima Prashad of rupees 2 lakhs and 214 expenses are paid within a period of 3 weeks from today. Next paragraph. In view of the aforesaid position and the prayer made by
with the Terai Tea Company.
Prayer made by Messrs. What's the name of the
Terai Tea Company, who's a specially petitioner.
Terai Tea Company Limited.
Is a specially petitioner in 28119.
That is a special petitioner for withdrawal of rupees 50 crores.
Yes, ma'am.
Together by this in this court, along with interest accrued if any, is accepted. Structure, the registry will please pay out rupees 50 crores along with interest accrued, if any, to Messrs. Tea Company Limited.
Lordship, I appear for SLRL. My 40
SLP can
crores
be withdrawn then, my lord. My SLP will not.
Lordship, my 40 crores is with the Registered High Court. If that could also be granted to be withdrawn, my lords.
What's your name?
Lordship, SLRL agencies,
Respondent
respondent number
SLRL
3.
agencies.
One minute, that prayer you make before the High Court now. We are not.
But Lordship, without a leave from your Lordship, because Lordship is taking care of the entire matter, we can just give us the leave, my lords.
In view of the order passed today, the senior advocate appearing for Tea Company states that he'd like to withdraw the present special petition. The special petition is accordingly dismissed as withdrawn. Rupees 10 lakhs deposited by Siliguri Jaipur Development Authority will be transferred to the High Court of Calcutta.
Siliguri is also filed in SLP.
Yes.
My learned friends have also, their SLP is there.
Your SLP will continue, or you want to press it, or you want to withdraw now?
We want an opportunity to
Okay.
hold on.
Then don't pass any order on rupees 10 lakhs.
But their SLP is
So,
pending.
Lordship, allow us to hold an option again, my lords.
We that we'll see after you give your fresh terms.
No, I will abide by law.
No, you decide. We want no difficulty. You decide your fresh terms, but make it reasonable. So that at least any person who can afford to take risk with the government can take. Simply, the authority can take that risk.
Lord, on that, Lord, I have two submissions. Lord, now
Lordship will grant me the liberty,
one,
my
Lord,
lords.
my friend is appearing, Lord. Positive before.
The special petition is dismissed and withdrawn. We must note that counsel appearing for
SLRL
SLRL
agencies.
Lord, if SJD's SLP goes,
no, your bid has been accepted before the High Court.
My lords, but that has been, the auction has been reopened by my lords.
No,
it's going to be a re-auction, my lords. So
we are
then,
not saying anything. We are not saying anything for the time.
Lordship, just
The order.
My lord, may just make a note of our IA also.
But their IA was dealt with, my Lord. They are trying to.
And we have an order in our.
It's not 16, 4,
16, 12, 25.
It's
4 to 24.
4 to 24.
Order date.
Next case, please.
Not two things, my Lord. Lord, in case they are not able to rebid, my Lord, or my Lord, something happens like this again, Lord, my money, my Lord, at least should be.
We are interested. Let them. We got to press them on the next date.
This has been happening with
Your
for the last
Lordship, allow us
years,
to,
my
Lord,
Lord. I filed my execution, my Lord, back in
conditions
20.
with your Lordship.
My lord,
List the specially petition preferred by Siliguri Jaipur Development Authority. Hearing number so and so be listed for hearing in the week commencing
46595.
4659 of 2025
595 of 2024.
of 2024. 4695 595 of 2024 in the week commencing 13th of May 2025.
my lord, the
And
26th
5
July
18,000,
2023 order of the Honorable High Court may be taken note of.
That has been dealt with by the single judge, my Lord. I can show right away.
Next case.
Not one point, not only one submission.
Mentioning the terms and conditions.
You please do it on your own. I can't
I
tell
will
you.
not accept Lord in the office, so.
They will do.
Not in fact, the terms and conditions are all.
That second is the specially petition. The senior advocate preparing for Siliguri Jaipur Development Authority states that they will be filing an affidavit enclosing therewith the fresh terms and conditions of the lease. So they are permitted to do so.
Not my cost of advertisement, which I paid initially, Lord. I mean,
That 10 lakhs is there now. We'll give it to you. Don't worry.
418 is there, not exactly.
No. We'll give you that much. Don't worry. We'll give you that.
And not meanwhile, also, if they can start the procedure of rebidding as well, Lord.
Let them come forward at least with the terms. Without the terms, how can you even bid? Nobody will bid. And that's what exactly has happened.
Lord, ultimately,
I don't know how did they think that. But money is paid and to be forfeited. You said that.
In fact, the terms were set by the single judge before the Calcutta High Court. The terms are already there with them.
We modified the terms as what we felt was proper. I can understand this saying 1 rupee is too little. I could understand that, and that the market value being such, it can be made a little higher. That rent should be, yearly rent could be made higher. We would have accepted it. There's no difficulty because we are not experts in market conditions.
But one more thing,
Going to market.
one more thing to add, Lord, why there's a problem with the state government, Lord, why I say so. The adjacent land, my Lord, in 2020 has only gone for 90 crore rupees. Same, Lord, land. There are now difficulties. This land is going for much more. So they are proposing terms, my Lord, which are adverse to everyone. They don't want anybody to take it. I can place that on record as well.
Anyway, let's see that.
My lord, 16 acres will be impacted.
Next case.
Wait, please. Lord.
400 crores someone is paid.
Matter we
No, this is a short matter. According to this is a short matter.
I don't think so.
Otherwise, we have a special bench.
I'll just take five. Just let me place the point. If your lordship feels it is
not complete. The resolution for take a decision.
This is a case where a property of a third person, which has been asked to be released by the committee of creditors, because at the behest of the suspended director now can't be released. He said now it has to be subject to CIRP, etc. Your lordship have issued notice on a very short issue. Please see the order.
Well, there's a moratorium in.
Lord, that moratorium will not apply if the COC
And
wants to give it back.
It's very interesting from this side to here. One council says it's a very short matter, the other council says we don't hear.
No, I'm not saying that, my lord. My lord, wait, take it up.
What else are you saying?
I'm only saying it will take some time because I'll have to show section 14, I'll have to show section 28, regulation 30.
You start on a negative again. You start on a wicket which says that please don't open up the file, don't consider.
I'm saying that please give me some time to respond because my learned friend may want to take 5 minutes. I'll have to show.
Otherwise, we'll continue next week if it doesn't get over.
That's what I
Let it be over next week.
I appear for the resolution professional.
Can it be next Wednesday at the top of the board? I'm just requesting. My property, I'm getting no rent for it also.
Will remain on board.
Lord, item 37 is the lordship can reflect. It is, my lord, that treatment plant, biomedical treatment plant, which is lying ready. Your lordship kept it early.
May I kindly mention item?
Next week, my lord.
Let's remain on board.
May I request for item 36 for a short date?
Can you keep that application?
Will remain on board.
Item 36 may I request for a short date?
No take in all. before anybody begins. We were just in the chamber and we spoke to each other and felt that given the time span all of us have on the bench, it may not be appropriate for us to pass any orders now. We will not be able to pronounce any judgment. So better course is, I'll leave it, give a date after 13, then it will be dealt with by the court.
Actually, my lord, there is already a judgment of 3 judges on the same issue.
Mr. We are aware, we have also gone through the matter. We have,
It's been deferred in the order itself.
we have,
I
it
understand.
will not be.
I have
Only one issue was there. It's a request made by the Delhi High Court with regard to a change of the judge. That was that request we'll accept. They've nominated. Have you nominated?
List of the judges.
Okay, give us.
On the last occasion, Lordship had asked for 5 names, so we've given 5 names again.
Lordship,
Special.
Okay, I'll just make my little inquiry and then
I have, my lord.
Yes.
But this was the order earlier passed, if I may pass on a copy. So I'm the special public prosecutor. Not all that I'm submitting is, my lord, we have 2 learned judges, my lord, holding the fort. My lord, if both are transferred, my lord, it will break continuity. Let them have, my lord, the senior judge for another 6 months and transfer. Just see the import of the earlier order, how this court, my lord, proceeded. It asked for a list of, my lord, 5 honorable judges. Then the court made the selection. That
there are 2 judges at the present moment.
Presently 2. There were initially.
What's their name?
They are, my lord,
Mr. Arun Bhardwaj. And the second one, my lord, is Mr. Sanjay Bansal.
Lord, on an earlier occasion, my lord, the first judge there was, my lord, Mr.
The second one is Mr.
Sanjay
Bansal.
The Delhi High Court wants both of them to be brought back.
That's why precisely, my lord, my submission.
But
But earlier, my lord, Mr. Bhardwaj had, Mr. Prasher had put in 6 years. These honorable learned judges have put in 3 years each. After that, I'm saying.
This is also sufficient.
No, my lord, all that I'm saying is the senior judge may continue, the other may be relieved.
Okay, let's see. Which one do you want more urgently?
My lord,
1 minute, I'm asking.
Mr. Bhardwaj is the senior judge, my lord.
They require.
We are rotated, we can't rotate other judges, and there's a little bit of problem within that.
No. What he's saying is, do not. Then one, you just tell us which one you want. Other one can be done after 6 months. Let the one judge be, because it takes you a little time in a file of this nature. It takes you a little time to understand the nuances, the issues involved. So one judge may be required over there. That's fine. He's right.
Not what all that I'm saying is let the senior judge be there.
No, don't be on that. Both of them have spent 3 years each. So that's fine. The senior, let's not pick and choose on that.
No, it's all. It's entirely up to my.
Because can I make a request?
Lord, just one small.
So you tell us one. You are paying for Delhi High Court. Who's paying for? No. But tell us one. You want Mr. Arun Bhardwaj to be back? Okay. We'll fill it up. Right up.
My clarification. My quash petition is pending before the High Court. Issue that happened. That petition is not proceeding any further. That quash petition.
No, we are just listing. I'll just list it in the week commencing so also. Then the bench will be nominated and it will be done.
Lord, on that, may I just say one small thing? Just one small thing. Lord, there are 2.
Even on this, you have to say. I thought there's nothing to say in this.
One very small thing. There are 2 issues about the order saying that you will not go to the High Court. One, of course, is jurisprudential, that Antule, etc., as to whether my right of appeal, etc. That'll take time. The other issue is, my lord, that order in ML Sharma's case saying that no High Court will entertain was an order in an ongoing thing. So therefore, that.
Mr. Bhushan, wait for your turn for. Right.
I'm not saying I'm not.
To be to be listed in the week commencing 13th of May 2025. Next paragraph. Mr. Arvind Bhardwaj, additional district judge?
Yes.
Additional district judge presently holding the court, presently acting as special judge, PC Act, CBI, is on the request made by the Delhi High Court is directed to be directed to be relieved of the present post, is relieved of the present posting. Stop. In his place, Mr. Swansop will take over as the special judge, PC Act, CBI, dealing with court matters, court and other connected matters. Stop. The request for relieving Mr. Sanjay Balsal from additional district session judge holding special court, acting as special judge, PC Act, CBI, dealing with court and other ancillary matters will be entertained after a period of 6 months.
It's my application exactly.
That will remain on board.
Because I'm not even being allocated a full block at the end.
So why are we here? That you tell you that you explain to the court where it is pending. No, but you explain it to the court in question where it is being misunderstood. If you agree by any order of that court, you can challenge it there. We don't require an order for that. No, I'm sorry, you don't require an order. No, you don't require an order for that. You don't require an order. All matters will come. We are not bifurcating, dividing any matters. They'll all come together. Give me first name and make it change. Huh?
It's like